to have this matter as an urgent motion matter. Also, your lordship directed Mr. Sunit Rai to take instruction regarding matter. Uh,
Adjourn. Yes.
you also directed Mr. Sunit Rai to take instruction whether the petitioner's contention is correct or not, because after
No. What is to be done now?
well, if you also, I have a talk with Mr. Rai, if you also can take their matter today at any time, matter. Only our direction upon the authorities to consider my representation, matter.
Consider your representation.
Yeah, matter, because the lady teacher, matter, her husband had undergone an open heart surgery. She also suffering from.
So,
Before posting, he made representation. She made representation and annexing the name of 5 schools. That was not considered.
yes.
At considering the physical condition, your lordship directed the landed advocate Mr. Sunidya to take instruction.
Hmm.
I have a talk right now. Just few minutes earlier, I have a talk Mr. Roy. Anytime if your lordship take up this matter,
Which item you said?
87,
87.
On Monday, your lordship heard this matter as urgent motion.
Come at 1 o'clock.
Matter.
Bring your other side.
I shall bring my.
I'll take to Niya's service.
May I have your lordship's kind leave, Miller, to move on matter on urgent basis from the determination of Justice Mitro. This matter pertains to Miller, the Pharmacy College. It is slightly different from the yesterday's matter, Miller. In this case, the petitioner has been granted affiliation by the PCI. Now, Miller, the PCI, for some reasons, is not uploading the name of the petitioner college in their website under the Miller heading of affiliated college. Now, that is the reason the state medical faculty, which is the examining body, they are not issuing the affiliation, Miller. Now, Miller, the examination, now, Miller, the admission process has already been started, and it is yet it will be concluded on tomorrow, that is on 28th. Now, Miller, kindly, Miller, allow me to move the matter at 2, Miller. It is not the case where that I have some discrepancies or deficiencies. It is purely, Miller, my affiliation has been granted, but my name is not reflected.
Matter also affiliation granted.
No, that is a different matter. That was a different matter because there, in those cases, the petitioner colleges had deficiencies. Here, Miller, there is no deficiency. Only.
How do you know? Was inspection conducted?
Miller, this is not the case of conducting the inspection. My initial examining body was the vocational council, Miller. Subsequently, Miller, I chose, Miller, the state medical faculty to be my examining body, and I took all the, Miller, consent letters from the council as well as, Miller, from the state medical faculty. Now, PCI has approved my change. It is reflected in their portal as approved, but not in the list of the, Miller, affiliated college. Kindly, Miller, allow me to move the matter at 2 because tomorrow is the, Miller, last date, Miller, for admission, Miller.
All right, is it affirmed?
Miller, everything is done, Miller.
Very well. 2 o'clock supplementary list.
Yeah.
But then you have to serve.
Miller, I shall bring my other side, Miller.
How will you bring?
Miller, Mr. Tiwari, Miller, is the main answering
Yes.
respondent, Miller.
And serve the state also.
Miller, I shall. Miller, I shall.
Leave the
Deeply
clock.
Your Lordship, I'd like to mention I have filed a writ against the
That matter, with regard to revert back to the post of Shoyak Shoika from para teacher, ma'am. You also passed an order yesterday, but today I have checked my lord, the order has been uploaded, my lord, but I have annexed that order in page 54, my lord.
My lord, I am on behalf of the mission. I am led by Mohammed Sarwaja.
Where is he?
Page 54, my lord.
Same order? 54 and 55.
I have paid the acknowledged receipt of my delivery.
Yes. 54, 55, same order.
Same.
2 তো একটা সময় রয়েছে।
I'm both the petitioner. Yesterday, my learned friend has taken time on behalf of the School Service Commission, which have not.
They appear on behalf of the commission, your lordship. They engaged before the honorable division bench, your lordship. I'm praying for a not today.
Not today.
Your lordship, they
Whole day they'll
and
be
your
engaged.
lordship, a Passover, your lordship.
What is your prayer?
Dear my lord, it is my lord, he appearing can. He
He?
my lord took a SLT my lord, second SLT 2025.
Yes,
Well, he my lord raised objection against my lord some question.
right.
And my lord, he made application and he said that the questions which was model answer, it is not the math over, but due to that reason, my lord, he made application that the answer he has given it is correct. So he made objection, but objection was raised, but has not been, my lord, yet taken decision by the commission.
No decision
Your
has been
lordship,
taken.
no.
Where is the objection?
My lord, your lordship kindly come to.
But in the meantime, the final result has come out.
No.
Then what is to be done?
Result come out before it, my lord, he made objection. It is pending. Your lordship kindly come to page 36.
Yes.
Page 36. I would request you to state that the answer 1, mark the questions 2 in booklet series is absolutely correct. And I had also challenged the questions with proper and authenticate reference during the official answer slip challenge period, and it appears that the marks of the question has not been awarded to me, which has been kept total score by 56.
What is the
My lord, your lordship kindly come to. That is my
what
lord.
is the cutoff mark?
Yes, cut-off marks, my lord, 1 mark short. Cut-off marks says, my lord, 35.
35.
Yes, 35. Against my lord, English subject, well, he scored, my lord, out of my lord, 66, 56, my 66 he scored. And my lord, cut-off marks, my 67.
Right.
Only 1 mark is my lord.
1 minute.
Yes.
And the your answer is which one?
My lord, your lordship, kindly 39, page 39. 2, series A series 2. That is, my lord, this is the answer, this is the question. The new teacher tried her level best to get dash her idea to her, my lord, students. He took much, my lord, through. Wait. But
Sorry,
model answer is, my lord,
across. Your answer is wrong. Please
What?
come. It will be across.
What?
The
my lord, your lordship, kindly
No, sorry.
come to my lord, kindly come to my lord.
petitioner is aggrieved by the manner.
Page
Uh,
42, Your Lordship.
in which his question has been assessed by the commission. Stop. The petitioner raised objection at the initial level. No, at the he raised objection within the time limit prescribed after publication of the preliminary model answer key. Stop. The final answer key has also been published. Stop. The answer given at the preliminary answer key level has tallied with the one given by the given in the final answer. Stop. The petitioner submits that his objection has not been considered. Stop. Paragraph. The petitioner claims to be 1 mark short of the cutoff. Stop. Prayer has been made to direct the commission to reassess the answer given by him. Stop. As it appears that the preliminary answer key was published and the answer given therein tallied with that of the final answer. Accordingly, the candidate ought to follow the decision of the expert in terms of the recruitment rules. Stop. There is hardly any scope to interfere in the instant writ petition. Stop. The writ petition fails and is hereby dismissed. It is only your name that will go down. What is your name?
Anushmita Bhattacharya.
My Lord, affidavit of service.
Yes.
Five, I am for the petitioners.
So I am for the state respondent.
The petitioner's grievance, 18 years benefit. Lordship, kindly turn to page 23. This is her first approval, 3rd April 2006. Page 23.
3rd April 2006.
You'll also kindly see he transferred to another school. You'll also kindly turn to page 28, release order. Why I am showing, my lord, I am coming to that. Page 28,
Yes.
26 August 2010, previous school he worked up to 26 August 2010, 14,370. This is the pay, last pay. My lord, the middle, page 28.
14,370.
Point number 8, just below.
Yes.
14,370. You will also kindly turn to page, my lord, the paragraph, page 6, paragraph 5.
What you state?
Just, my lord, what I am saying, my lord, you will also just, my lord, kindly see. Page, paragraph C, page 6 of my writ petition.
Yes.
That is Roman 1, 14,370. This is the last pay of the first school, previous school. Second school, 14,370. Same, because he transferred to another school. My lord, the Roman 7, 16,690 as on 1st July 2015. That is 1st January 2016. You will also kindly turn to page 30, 30. Kindly, my lord, the 30. This is the ROPA 2019. Pension has been revised. Page 30, 30. You will also kindly see serial number 5. 16,690 as on 1st January 2016. So there is no dispute regarding continuation of his service. Now you will also kindly see impugn order, page 53. I moved a writ
Page
petition.
50,
53. I moved a writ petition. Court directed the authority to
consider.
take a decision, and the decision has been taken. Just your lordship, the 3 pages. I am not reading entire. Page 54, second paragraph. Thereafter, the headmaster of such and such school, by reference dated, approached the approached this inspectorate for granting 18 years continuous service benefit in favor of the petitioner, who completed 18 years continuous service on to 2nd April 2024, because the 2nd April 2006 he joined, and grant her 18 years benefit if her service is deemed satisfactory by the DI. Next paragraph. In addition, the headmistress of the school also enunciated that the managing committee has resolved at the meeting held on 20th April 2024 by praying West Bengal Board of Secondary Education for taking disciplinary action against the petitioner. In pursuance of the in pursuant to the Deputy Secretary Board by memo dated such and such, DI has already sent a preliminary inquiry report to the board. After that, no communication has been received from the competent end. Only this reason, they say my service has not been satisfactory. My lord, no disciplinary action has been taken. I don't know what is the inquiry report, what is the complaint. Only in order to, my lord, withhold my 18 years benefit, my lord, the headmistress intentionally, my lord, this observation has been made before the DI, and my lord, on the basis of that, my lord, the inquiry has been report has been made. Nothing, my lord. You also kindly see page 55. Next page.
Let them file their stand, because the board stand, the DI stand, everybody stand. Who passed this order?
DI.
And you'll also kindly see why I am, my lord, I showed, my lord, the continuation of my service. DI observation page 55, second paragraph. It finds that the present school authority has started the pay of the petitioner while joining the school at amount 14,370 as on 27th August 2010. On the base 27th August 2010, my lord, I last pay. On the basis of the last pay due at the Ashtroy school without getting a proper approval from the competent authority. What approval is required? Automatically, my lord, the release order has been made by the school authority, and my lord, I joined the present.
There's one disciplinary proceedings is going on. Second, no service record is available in the school authority.
Service record will not be available.
I am for the school authority.
And lordship,
School.
Yes.
Yes.
My lord, DI has written to me to furnish certain documents with regard to petitioner service record, my lord. I had received that email, my lord. Subsequently, my lord, I had forwarded the same to the incumbent, my lord. Kindly furnish these documents. Now, 3 documents were never supplied to me. Now she has written a letter to me showing that yes, I have submitted all the documents. Now, my lord, I have scanned all those documents. Now I have called her. Now she has given a letter in her.
What documents? She is an assistant teacher. She is the headmistress of the
Wait,
school.
1 minute. Yes.
Your lordship kindly sees, my lord, the documents which I sought for from a personal direction which was given to me by the DI, my lord. These documents were never supplied to me.
What are the documents?
My lord, service no objection certificate from the Ashtroy school, my lord. That has to be submitted to me.
She's joined in 2010. In 2020.
My lord,
you ask all these documents?
No, my lord, these documents has been sought for by the district insurance schools, my lord, from me. Until unless she gives me the document, how can I forward? Your lordship kindly see. I will.
What were you doing for so long?
Now, my lord, only one example I'll tell you. Your lordship kindly take pen, my lord, to come to page, my lord, 26 once, my lord.
No, you whatever you got to say, you say in your report. Please come. The order passed by the District Inspector of Schools, Secondary Education, Kolkata, on 5th December 2025, rejecting the petitioner's prayer for grant of 18 years service benefit is impugned in the instant writ petition. Stop. I have heard the submission made on behalf of the petitioner, comma, the state and the school. Stuff.
And she also getting the salary without proper approval of the DI.
Why? Who's stopping you from approving a salary? The service. She got appointment in 2000, when? 8 or something.
2006.
2006. And now it in
And
26.
second school approval has been accorded by the KI.
26, you say her service has not been approved. Who is responsible?
Salary is not have been properly.
Who is responsible for this?
That is
Service has been approved.
Yes,
This is the approval letter.
Try to understand. It is you who are not acting, and now you say her salary is not approved. It is your responsibility. School stuff. The respondents are directed to file report by way of affidavit, disclosing their respective stand.
করে দিয়েছে। যাতে আটকে যাবে।
File বললাম তো ওখানে করুন, prepare and circulate the affidavit within a period of 6 weeks, reply if any within a fortnight thereafter. Stop. Liberty to
But the-
mention the matter for hearing immediately on conclusion of the aforesaid time period. Board is not a required party, you say?
Yes, the proceeding is going on.
Proceedings. No proceedings has been
It
initiated.
appears from
Only
the
inquiry. All the board will be party.
Choice is yours. Whether you add, you do not add. Right now it is not there, but from the order that you read out, I could hear that a proceeding was there before the board. An inquiry was also conducted. Thereafter, silence.
One report is also submitted.
Thereafter, silence.
Silence. No so-called nothing.
Your call. ঠিক আছে।
The report in form of affidavit and exception or affidavit and reply. The
No, report in the form of affidavit and exception.
exception. So the matter is not ready. The lawsuit directed to matter will appear.
You mention it for
6 weeks.
Not for heading.
6 weeks liberty to mention.
Yes, yes.
Today to do it.
Not for heading hearing. পরেগুলো করে দাও।
Yes.
তো পরেগুলো দাও।
But after the petition. And this matter, my lord, has got a checkered history, my lord. This incumbent, my lord, initially, my lord, sat for the 12th RLST examination back in 2011.
State, is anybody appearing?
No, my lord, Mr. Tulsidas is appearing for the state, my lord.
Yeah.
He's Tulsidas Roy, my lord.
Yes.
He's trying to connect in online, my lord, but he cannot, my lord.
He is appearing for the state.
State, my lord, state.
Why not? Everybody is connecting.
No, my lord, due to some network issues, my lord.
No problem at this end. Check up at your end.
That is a problem.
State is the answering response. State is the answering response. What is to be done?
So, my lord, if I just briefly could say, my lord, because
In the absence of the state,
No,
any interim order?
No, there is no interim order. I'll just request them, my lord, so that they can file a report in the form of an affidavit.
All right, what is your challenge?
Yes. So here, my lord, what happens? Well, just very briefly, my lord, if I could say that 12th RLST I sat for, my lord, I was not eligible. I was said to be failed. I challenged, my lord, those orders in 3 rounds of litigations. Each round, the School Service Commission said no, answer was not right. Answer was not right. 4th time, they said no, answer was right. And I was, my lord, given in the employment back in 2022. Thereafter, my lord, I said that this my lord is a peculiar situation by which I should be, my lord, given the benefit that that actually, my lord, if I would have been properly engaged in back in 2013, I would have got. So, my lord, that was not given. I came before this honorable court. This honorable court directed that yes, notional benefit and also the benefit which is actual should be given to the persons. One, there has been an observation. Thereafter, my lord, but this honorable court directed the prayer of the petitioner to be considered. So after consideration, this principal secretary of the school education department says that yes, it is a peculiar situation and in which the notional seniority has to be granted, and about the financial benefit, because this particular person, my lord, has been really deprived.
So what is to be done? Tell me, please.
So now, my lord, the state, the finance department said that no, she is not entitled with the financial benefit.
Yes,
But
that is
came
under
before
challenge.
No. But she came before this honorable court, that was dismissed, went before the honorable division bench. The honorable division bench said no, this is a situation where the no work, no pay should not be followed. Once again remitted to the department. Department said again no. That is under challenge.
Department means?
The school education department as well as the finance department. The school education department basically did not, but the finance department finally rejected my case. So, my lord, if I just take your lordship, my lord, to the last order.
Page 135, I can see.
Yes.
Pay and allowances become admissible only when an employee actually joins and
Yes.
serves.
Yes.
Discharge. Did not join, scope. Give him actual service benefit. You want your salary also or not?
My lord, yes.
You want your
Actual
salary
benefit,
also
yes.
without working?
My lord,
Let them file their stand.
so this is why I said, my lord, for the very beginning, my lord. Because this is
The
after the
petitioner is
honorable
aggrieved
division
by
bench.
the order passed by the additional chief secretary, finance department. On 29th of July 2025. There is hardly any scope to file any, to pass any interim order in this matter at this stage. Let affidavit in opposition be prepared and circulated within a period of 6 weeks. Reply, if any, within a fortnight thereafter. Stop liberty to mention the matter for hearing immediately on completion of the aforesaid time period. Just show me one thing.
Yes, ma'am.
Where the court passed order for disbursement of actual financial benefit.
No. The court observed. The honorable court observed.
I got it.
Or the affidavit of service.
Yes.
But on the earlier rejection, the honorable division bench said that this is a peculiar situation, it should be considered. The honorable division bench. Then, my lord, they again reject.
No order has been passed for passing on of the
No.
financial
I could have-
national benefit. I understand.
No.
But then, I do not know.
Yes, ma'am. I should be grateful.
For item number 7, I beg to appear on behalf of the petitioner. This is relating to 3% additional increment, my lord.
But I'm
Lordship's order and affidavit of service. But there was no correction to one thing was correct. Email order maybe.
No, সেটা ঠিক আছে, ওটা একটু type it.
Same order.
But only thing, they have not made any representation. What is under challenge, they have not stated in this petition, my lord.
Yes.
Only that is the point.
That is exactly what the order is.
Lordship. Madam, may I file the report, my lord, filed by the
If you have, please give.
lordship. Report may be kept to the
Report to be written with the records.
lordship.
Yes.
Item number 8, my lord, this is also similar issue, my lord. My lord, kindly. So, affidavit of service and your lordship's order.
Same order. None for the state.
Item number 9. My lord, I am for the petitioner, my lord, in this.
I am
This
for
is
the
also
state,
similar matter, my lord. 3% additional increment.
You have a report?
Yes, sir.
Please keep the report on record and the same order to be passed. Order to need.
I'll get the copy down.
Report a copy.
Get the report a copy.
Then, my lord, I am appearing for the petition, my lord.
Who's your other side?
Yes. Okay, not today, kindly keep it at 2 p.m., my lord, so that I can inform my other side.
No.
2 p.m. it cannot be kept.
My lord, 1 p.m.
Prior to recess, if you can come, then it is all right.
And
All right.
my lord.
Pass over. 10 pass over.
But for the
And for secondary
my
board.
lord, this is my lord against the order, my lord, rejecting my HRA. So my lord, here the situations are completely admitted and settled. So this is why I just beseech, if your lordship, the my learned friend, my lord.
Where does your spouse serve?
My lord, my husband, my lord, serves in a private sector. Oh, it is fine.
I am first.
So my lord, here this HON'BLE court in Moshumi Bishas matter, my lord, has already settled.
Where is the rejection?
My lord, lordship would see the rejection, my lord, at page number 105, my lord. My lord, there has been a mentioning of the memo at the bottom of this 105 page.
Hmm.
My lord, lordship has seen 27th December 2018
Hmm.
and my lord,
9th July 2012.
9 July 2012 is there. Thereafter, my lord, this 9 July 2012 is of the memo of the West Bengal, my lord, the under the WBSR. So,
Hmm.
which is applicable to the West Bengal employees. So, that was given effect to the teachers by way of this 27th December 2018. And that was under challenge before this honorable court on the earlier occasion. This honorable court on the earlier occasion in paragraph 43, 48 in Moshumi Bishas has set aside this memos of 2017. So even that was back in that was back in 2024. But even in spite of that, they have been rejecting the claims of this HRA, so citing the same memorandum which is already set aside by this honorable court.
What is your submission? Dekhi, Manish babu? Yes.
Lordship, as per my instruction, Lordship, state already filed an appeal, Lordship. But after I checked it, Lordship, it already dismissed for default on last December, Lordship. Now,
Nothing remains.
And that ground is also taken in another honorable coordinate bench. And my lord, the dependency of the appeal, the honorable court said no, it is not a ground, as your lordship has done. But paragraph now 48, if your lordship sees once. And 49.
But the memo number is different.
My lord, 48 and 49, there are two memorandums mentioned.
Clarificatory memo 5839. Please come. The petitioner is aggrieved by the order dated 21st of November 2025, passed by the District Inspector of Schools, Secondary Education, Barakpur, rejecting the petitioner's prayer for grant of house rent allowance. Stop. A specific submission of the petitioner is that her husband works in a private organization and she would be entitled to receive the house rent allowance. Stop. In support of the submission, in support of such submission, learned advocate for the petitioner relies on the judgment delivered by this court in the matter of court in a batch of writ petitions, first of which is Moshumi Biswas and another versus State of West Bengal and others, reported in 2021 SCC Online Cal 524, wherein the court was pleased to set aside the clarificatory corrigendum dated 27th of December 2018, holding it to be inconsistent with the service rule of the teachers. Stuff. Next. An appeal preferred against the said judgment stood dismissed by the Honorable Division Bench. Stop. As on date, the judgment passed in the matter of Moushumi Biswas within bracket Supra holds the field. Stop. By the impugned order, comma, the DI rejected the claim of the petitioner, relying on the government order number 5839-F within bracket P, dated 9th July 2012, and its corrigendum number 8012, dated 27th, page 105, 27th December 2018. Stop paragraph. As it appears that the government order, that the clarificatory note relying on which the prayer of the petitioner stood rejected by the authority was long set aside by the court, comma, accordingly, the authority ought not to rely on the same. Stop paragraph. In view of the above, the impugned order is liable to be struck down and is accordingly set aside. Stop. The District Inspector of Schools, Secondary Education, Barakpur is directed to reconsider the prayer of the petitioner strictly in the light of the judgment passed in the matter of Moushumi Biswas within bracket Supra. Stop. An opportunity of hearing shall be provided to the petitioner for production of documents in support of the stand that her husband works in a private organization. Stuff. Next. A decision shall be taken by the District Inspector of Schools at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stuff. If the prayer of the petitioner is allowed, comma, the necessary consequential steps for releasing house rent allowance shall be taken without any further delay. Disposed.
Together with the interest, my lord, I just pray.
As the petitioner would be entitled, if the petitioner is found to be entitled to any payment, comma, the same shall be released along with interest, simple interest, calculated at the rate of 6% per annum on and from the date the same fell due till the date of actual payment.
Grateful. The affidavit of service.
Service is taken on record.
Back to the show.
My lord, on for the state respondent led by Mr. Joydeep Banerjee.
But here the petitioner, my lord, has challenged the order of the disciplinary authority of censure, my lord, to the appellate authority, which is Commissioner of the School Education. So, my lord, these very specific grounds for challenges, my lord, are, my lord, that the appellate authority, which is Commissioner of School Education, my lord, has went beyond, my lord, the charge which is framed against the petition. One. Second, my lord, has taken into consideration of some facts which are after the charge sheet which is framed.
All right. So page 164 and 65 is the impugned order of the commissioner.
Yes.
Let them file their
That is my prayer.
respective stand.
Yes,
the order dated 5th December 2025, passed by the Commissioner of School Education, West Bengal, is impugned in the instant writ petition. Stop. There is no scope to pass any interim order in this matter at this stage. Stop. The respondents are directed to file their respective affidavit in opposition within file jagah, prepare and circulate. 6 weeks. Reply 2 weeks. Liberty to mention for hearing.
Grateful, my lord. The affidavit of service.
Yes, service.
রিপোর্ট দাও দিদি এই পয়েন্টটা এটা পয়েন্ট met with the lord. My lord, here, my lord, the managing committee of a school have come before your lordships against, my lord, by specifically, my lord, contending the allegation against the headmaster of corruption my lord, and different several other allegations. So, my lord, I have stated that in my petition as well as, my lord, I have made that representation to the board. But my prayer before your lordship that the applications which I made before the board, they have not been taken into consideration anything yet. So if I
Did you serve?
yes, my lord, yes.
No, but then private respondent is also there. When did you serve?
My lord, I served, my lord, I tell your lordship. 20
Show the affidavit of service.
1 second,
the
madam.
private respondent.
15th of January 2026. No, my lord, I did not. My service on the private respondent is not yet served.
Right.
Is not yet finalized, my lord. So all requests, if I just could request your lordship, my lord, if my learned senior, my lord, would file a report on the allegations that I have made. Thereafter, if your lordship, my lord, is satisfied with the report, then whatever happens. And in this meantime, I'll be serving on the private respondent as well. Yes, আমি দাদি
Certainly.
আমি পুরো copy সব
Where
করে
is your representation or something?
My lord, my representations, my lord, start from, my lord, page number 63 onwards.
63 onwards.
Several other representations. 63 onwards.
Where is the seal of the board?
No, my lord, I tell your lordship. The board. Bikash Bhavan, lordship will see at page number 63.
Bikash Bhavan, there is no.
I will, yes.
It has not reached board.
আচ্ছা ভালো
Ah,
Nivedita
না, আরো
board,
আছে
Your Lordship.
প্রচুর আছে।
service of the writ petition is not complete.
Yes.
No, no,
Let service be made.
this is not a service, this is the representation.
List on 2nd of March. Service in the meantime.
ওই জন্য ভুল হয়েছে।
As your lordship. না না আমি present
Next.
না না প্রেসিডেন্টকে করতে পারিস কিন্তু যদি বিকাশ ভবনে পাঠাস তাহলে তো যাবে না।
grateful.
কবে বললি?
The matter
2nd March. Combined list it will appear. Now I do not know. Combined list will be published.
this matter relates to 3% increment. So far the headmaster is concerned. Now the headmaster was appointed after the school being upgraded on and from 27 July 2009. Now the circular you also knows, page 24, relevant page 26.
Yes. What is your prayer?
3% increment has to be given to me in view of the settled issue.
Did you apply before the authority for increment?
No, they had been withdrawn. The circular which has been
Did you apply
I have
for
challenged. I have challenged the circular
which circular?
because the dates 24th by law the increment which has been given to me that was withdrawn by the government.
Show me.
Yes. Kindly, first of all, kindly see the page 26.
Show me the withdrawal. Where is the
Yes,
payment
withdrawal.
of the withdrawal?
Withdrawal page 34.
This is in 2017. And you
Yes.
filed the writ petition in 26.
Because the issue has been settled by this by honorable court. Kindly see.
Yes, but why did you file the writ petition after such a long delay?
But issue, my lord, kindly see the COVID judgment. But this issue has been settled, my lord, in 2021. Thereafter, my lord, the
Show me the withdrawal.
withdrawal.
Where is the withdrawal?
Yes, page 34.
This is a general memorandum issued
Yes.
by the school education department. Where is your withdrawal?
No, so far my withdrawal is concerned, there is no.
Did you ever get the payment?
I am not getting any 3% benefit.
3% order টা আছে দিয়ে দেবেন তো?
No.
Yes, next. Disposed.
But the father of the petitioner was the laboratory attendant of a school, my lord. My lord, he appointed on 11th September 1999. And therefore he died on 5th December 2024. But immediately we made representation, school authority forwarded by representation stating that I am in distress condition. My lordships, kindly see the impugned order.
Yes.
And before that, lordships, only one thing, page 36. In the impugned order, it has been stated the income of my grandmother was also taken into account. But my grandmother was survived with 8 legal heirs. Kindly see page 36. And then, my lordships, kindly impugned order, my lord, page 33, my lord.
You are Anirban Shah.
My father, Ajay Kumar Saha, and my grandmother resided in his native village, that is at Sagorpada. This certificate has been issued by Sagorpada Panchayat, Gram Panchayat. I resided at Sonarandi, that is nearby Katwa, and this is nearby Domkol, Sagorpada. My grandmother resided there with my younger uncle, Sujay Saha. But her pensionary benefit has been taken into account when my compassionate appointment was rejected. That is page 10, page 33, my lord. Lordships, kindly see, only on that ground alone, my mother received 5,000 pension. And lordships, kindly see the circular. The family definition is only 3. No, ওটা আছে circular-টা। এই দিয়েছি আমি দাদা। Kindly see.
Schedule 5.
Schedule 5. And this is the family definition, my lord. Spouse, son, daughter. দিদি আছে আমার কই? দিদি আছে আমার সঙ্গে? Sorry. না, ওর রাখবেই। এখন কিছু অ্যাডভোকেট আছে যারা জেনুইন সাবমিশন করে, আর কিছু অ্যাডভোকেট আছে যারা একটা জায়গায় বড় হতে গেলে
আদার সাইড হয়ে দাঁড়ালেই অপোজ করতে হবে না।
This is
হচ্ছে
কি করে ধরেছে? ধরতেই পারে।
Yes.
No, my lord, my submission before the order is illegal. And let it be set aside that.
Show me that notification where the income where there is more than 3 members. More than 3 members, Dekhi. What is your submission?
I'm for the school service commission. As per my understanding, he is entitled.
Because the
of
calculation.
The family definition of family includes 3, my lord.
Above 3, there is a separate calculation.
Above 3 means, my lord, there must be another son or daughter, not the mother.
There, the definition is also different.
And another thing, my lord, EPF amount
Cannot be.
Cannot be. 40% of the pension should be, my lord, taken into consideration.
Absolutely. EPF, DA, everything is calculated. What is your stand? No, it is your client's order and you have to defend it. How do you defend? The petitioner seeks family pension. Appointment on compassionate ground. Stop. His father died in harness on 5th December 2024, leaving behind his grandmother, his mother, and himself. Stop. The District Inspector of Schools, Secondary Education, Murshidabad, calculated the gross family income of the petitioner relying on the government notification being memo number page 33 697 9th July 2009. Copy করে নেবেন।
না না এই যে
And
40%।
came to a finding that the earning of the family
আমি ইয়ে করেছি কিন্তু
monthly income of the family at the material point of time exceeded the gross salary of a Group D employee of the state. Stop. For the purpose of arriving at the aforesaid finding, comma, the authority took into consideration the provident fund amount, comma, the dearness allowance, and the pension received by the grandmother of the petitioner and the mother of the petitioner and his mother. Stop. The petitioner is aggrieved by the same. It has been submitted that the provident fund and the provident fund, comma, dearness allowance and pension ought not to be taken into consideration for calculating the gross monthly income of the family. Stop. Paragraph. You didn't bring the judgments. There are so many judgments in your favor.
The rules also specifically provides what should be the calculation. In the schedule 5, it has specifically stated.
As per the definition of financial hardship prescribed in Schedule 5 of the West Bengal School Service Commission, bracket open, selection of persons for appointment to the post of non-teaching staff, bracket close, rules 2009, laying down the procedure, comma, manner of application and preparation of panel for appointment on compassionate ground, that for computation of income of the family, the income of the amount earned by each member of the family apart from the provident fund, gratuity, and 40% of the family pension of the first 7 years, or upon attainment of 67 years of age of the deceased teacher, had he been alive, is to be taken into account. Stop. In the instant case, the surviving members of the deceased family includes the spouse, comma, son, and the daughter. Stop. Paragraph. In the instant case, the authority erroneously took into consideration the amount received by the petitioner's grandmother and the amount received on account of provident fund and dearness allowance for calculating the financial income of the family. Stop. The same is contrary to the rules. Stop. Next. In view of the above, the impugned order dated 5th December 2025 stands set aside. Stop. The District Inspector of Schools, Secondary Education, Murshidabad, is directed to reconsider the prayer of the petitioner for grant of compassionate appointment, strictly in accordance with the prevailing rules at the earliest, but positively within a period of 8 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to the petitioner. Stop. If the petitioner satisfies the eligibility criteria for being appointed on compassionate ground, comma, the necessary consequential steps shall be taken without any further delay. Disposed.
Grateful, my lord, highly obliged. Circular. The circular. My lord, affidavit in service kept on record, man.
Yes.
I am for the petition. This is also similar matter leading to 3% additional increment, my lord. My lord, this is your lordship's order and
Yes.
the affidavit of service, my lord.
Yes, please.
But there's no,
For a
there is no cause of action, there is no representation, nothing on this, sir.
All right. Dispose. Same order.
Grateful to your lordship.
My lord, since there is no representation, my lord, is he going to get an order in favor, my lord?
Yes, leave is granted to him to file the representation.
Okay.
Yes. 17, my lord, I am for the petitioner. This is also similar matter, my lord. 3% additional increment, lordship's order and affidavit of service. 17.
70. Well, 70, my lord, I am for the, my lord, the state of withdrawal.
Disposed.
My lord, only, my lord, he did not file any representation for claim.
That is the reason leave is granted to file representation. This
As
is
you
the
are.
only order passed.
Yes, sir.
Next.
Capital.
18, my lord, I am for the petition.
I am for the state.
This is also similar issue.
Why are representations not filed and the writ
At
petitions
that
are
point
filed?
of time, there was
At that point of time, these matters are filed in January.
subsequently when the leave is granted, my lord. All of the
But
matters
that
were
does not mean that you will come on filing writ petitions without the representations.
subsequently we have made representations, my lord. There are certain
Alright.
matters at that point of time which is filed no representation.
Disposed.
I'm grateful to you. 19, my lord, I am for the petitioner. This is also similar.
Yes.
I'm grateful to you. 20.
This is a
এটা কি রিপোর্ট আমাকে একটা কথা রিপোর্টে দিয়ে দাও
কোনটা?
পেপার ভেতরে
হয়ে গেছে।
For the state service.
Petitioner retired.
Are you all appearing together?
I'm, yes.
Petitioner retired from service 31st January 2026, last month. He was the headmaster. The page 26, e-pension page 26, e-pension application was submitted through portal for pensionary benefit. Page 26. That was submitted in 2020. Now
Submitted in?
E-portal, this is the e-pension application.
Well, page 26, what is the date?
That is the right-hand side.
22nd of May
25th
2025.
April 2023.
23. All right. 3 years prior to retirement, he submitted his e-pension application.
The thing is that he also.
So that is the, sorry. 28th May 2025. Resubmitted.
The first submission was in April 23. Or is it 25?
Not 25, however.
Yes, the petition was also filed before the retirement.
No, that is not the disputed.
Did he file after retirement?
No, the thing is
No,
that.
that is not the dispute. I tell you. What is the dispute? Page 36, hard copy has been submitted before the DI. 22nd May 2025. Along with all, my lord, the e-pension application, part A, part B, part C, part D. But the page 36, before the DI. Lordship will find page 42, my lord, since the petitioner was the headmaster, my lord, the signature of the president is required. And all the paper, presidents, my lord, they refused to put his signature. Without signature, my lord, the petitioners, my lord, submitted, my lord, page 36, all the papers by forwarding letter dated 22nd May 2025. My lord, they repeatedly requested the president to put his signature. He did not, my lord, she refused. Ultimately, page 50, seat resigned. Resigned from the post.
Resigned?
Resigned from the post of president. My lord,
Oh, resigned from the
resigned.
post of president.
My lord, since the PT, my lord, the erstwhile, my lord, the president tendered resignation. My lord, the headmaster of the school, my lord, the wrote a letter, page 52. Another gentleman has been, my lord, the appointed as president. Page 52. Soumitra Pandit. And you will also will find page 63 as per order of the DI. All the documents, my lord, collected from the said, my lord, nominated persons. My lord, they submitted the documents, also page 54. Now the present president also, my lord, the declined to put his signature. Now,
why?
My lord, now the present president has not yet assumed charge also, my lord, as president. That is the problem. My
page 52, 11th of November. Head of the institution will be secretary. Existing such and such.
That is the appointment, nomination appointed, my lord, the president.
Soumitra Pandit.
Soumitra Pandit.
Then did he take charge?
Has not yet. My lord, the only documents as per the DI has been submitted.
From November, this person, Soumitra
No
Pandit
meeting,
has...
no assumed charge. That is why, my lord, my pension, my lord, has been withheld by the DI. DI said, my lord, without signature of the president, I have submitted, my lord, by forwarding letter without putting signature of the president. This is the, my lord, the whole difficulty. You will also direct the DI to take steps so that I can, my lord, get my pension revenue.
Yes.
Well, steps have been already been taken, my lord. This is the last letter which has been written to the managing committee, my teacher in charge of this school, to take immediate, my lord.
The president is signature required, right?
Is there a teacher in charge in the school?
Yes. Now the teacher in charge has been appointed.
Please come. The petitioner retired from service on 30th of January 2020, 31st of January 2026. Stop. Though he submitted his application seeking pension online on 22nd May 2025. No, first day, 25th April 2025. And resubmitted the same on 22nd May 2025. Comma. The hard copy of the application could not be filed as the same has not been signed by the president of the managing committee. Stop. In November 2025, a president was nominated in this school, but the president is yet to take charge. Stop. Because of non-signature of the president, comma, the pension file of the petitioner has not been made ready. Stop. The petitioner seeks for a direction upon the district inspector of schools to take necessary steps so that the petitioner may receive his terminal leaves. Paragraph. Learned advocate representing the state respondents relies on the communication of the district inspector of schools, secondary education, Purbo Medinipur, signed on 24th February 2026, addressed to the teacher in charge of this school. The teacher in charge has been requested to take necessary steps in the matter. Stop paragraph. It appears that the teacher has retired on 31st January 2026, and long prior to retirement, he submitted online application seeking pension. Stop. As the president of the school managing committee did not put his signature, comma, the hard copy of the application form for pension has not been received by the District Inspector of Schools. Stop. As the teacher rendered service for a considerable period of time and is eligible to receive pension, accordingly, the District Inspector of Schools, ought to take all necessary steps to ensure that the pension file of the petitioner is made ready without any further delay. Step. All necessary steps shall be taken by the District Inspector of Schools to ensure that the pension file is completed and forwarded to the DPPG for issuance of PPO in favor of the petitioner. Step. The DI shall take steps to ensure that the PPO is issued in favor of the petitioner latest within a period of 4 months from the date of communication of this order. The petitioner, the teacher in charge of the school are directed to render all cooperation to the DI for making the pension file ready so that the PPO can be issued within the time limit as specified herein above. Dispose service taken up record.
4
Instruct.
months, my lord, I will not get any amount, my lord, even gratuity. 3 months, my lord, at least. Kindly, my lord.
Don't bargain. The election is coming in the meantime.
No, the election, my lord, the 4 months, my lord, at the date of the
Please do
election.
not bargain. Yes, 21. Yes.
Appear for the petitioner. My lord, your
This
lordship.
is your other side.
My lord, other side, my lord, was served in the GP office. They told, my lord, as instructed, my lord, they told that 48 hours notice is required, my lord. Then I the department director.
Then now you had enough time. You could
Well,
have served.
I can say, my lord, yesterday your lordship disposed one matter regarding higher pay scale. Physical education teacher, my lord, the same is here. Here is no rejection order. This lady is already a.
No, but in the absence of your other side, can I pass any?
My lord, may I indicate the advocate who has appeared yesterday for.
Advocate who has been engaged by the GP office?
No, not by the.
By the department?
No, yesterday, but the person, my lord, he is also the who has appeared yesterday.
No, that way it cannot be done.
My lord, your lordship may record one order that I will serve the GP office now and take it up the matter to 2 o'clock, my lord, today. Identical order, my lord. Yesterday I indicated, my lord, that.
Maybe, but it cannot be done that way. None appears on behalf of the state respondents.
Yesterday, my lord, my learned friend appeared yesterday for the state.
Actually, I have not been engaged, my lord, in this matter
Yes.
from the office of the government pleader.
If the court directs your engagement, then it can be done.
Lordship, it's my pleasure, my lord. It's my pleasure.
None appears on. Give me your affidavit of service.
My lord.
None appears on behalf of the respondents. Stop. Paragraph. What is your name?
Mr. Nirmalo Bishwas.
Learned advocate who's present in court and who usually represents the state before the court is directed to enter appearance on behalf of the state respondents and defend the matter on behalf of the state. Stop. Let a copy of the writ petition be formally served upon Mr. Nirmalo Bishwas, learned advocate. Stop. The government pleader is requested to regularize the engagement of Mr. Biswas, learned advocate. Stop. The issue in question has been decided by the court. In the matter of, give me, I have forgotten everything.
My lord, it was in the matter of my lord, may I just Madhumita Banerjee versus State of West Bengal. My lord, I am indicating the writ petition number. Madhumita Banerjee versus the State of West Bengal. WPA 29770
Of
of 2025.
25. And yesterday's matter, case number.
Yesterday's matter, my lord, is yesterday's matter. Your lordship passed order.
What is the number?
29770
Oh, এইটাই কালকে হয়েছে। আচ্ছা ঠিক আছে।
of 2025. My lord, only one difference in that matter. Impugned order, there is a rejection order. Here, my lord, there is no rejection order.
Then it has to be considered. Where is your request? Where is your request?
Yes, my lord, my request, my lord, is at page
26?
My lord, my first is at page 25, that is in 2005. And then, my lord, after I was a party in the special bench, my lord. This is the order, my lord. I was a party in the special bench. That is page number 2, my lord, Rinku Sarkar. I was a party in the special bench. And my lord, again, I made a representation after the order passed by the special bench at page 29. Rinku Sarkar, I was a party in the special bench.
আচ্ছা ঠিক আছে।
উৎপল কান্তি করণ।
ঠিক আছে। You must have mentioned it in your writ petition?
Yes.
তাহলে ওটা লাগবে না।
Para 10 I have mentioned.
ঠিক আছে, WPA 12414
পেলাম না কিছু না।
para 10.
Paragraph 10. Accordingly, the petitioner filed a writ petition being number 12414/2008. And that is in the larger bench, my lord. It was considered.
All right. Then where is the representation?
First representation in 2005, that is at page 25.
Yes.
And thereafter, my lord, after the larger bench, I have filed a representation, page 29.
All right.
And thereafter, my lord, DI has taken all the papers, my lord, still keeping it pending.
Acha. The petitioner's prayer for higher scale of pay. On enhancement of her educational qualification in
Physical education.
On attaining the postgraduate degree is pending consideration at the end of the District Inspector of Schools, Hooghly. Stop. It appears that several communications were made by the DI to the secretary cum headmistress of this school as regards the prayer of the petitioner, but final order is yet to be passed. Stop. Next. In view of the above, the instant writ petition stands disposed of by directing the District Inspector of Schools, Secondary Education, Hooghly, to take a decision on the petitioner's prayer seeking higher scale of pay, strictly in line with the judgment passed by the special bench in the matter of Utpal Kanti Karan versus State of West Bengal and others, and ওই Madhumita Banerjee যেটা হলো mentioned herein above. Stop. A reasoned order shall be passed and communicated to the petitioner. Stop. An opportunity of hearing shall be provided to the petitioner for production of all documents in support of her claim for higher scale of pay. Our decision shall be taken at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Disposed.
DI shall also consider that the petitioner was a party in the larger bench also.
In the light of the decision বলেছেন আমার কি?
Karan, K-A-R-N, where the petitioner was a party. Yes. All right, disposed.
I'm grateful.
22.
Yes.
I'm for the petitioner, my lord. The petitioner is on the verge of retirement. Tomorrow he will retire. Just I'm informing you. My lord, the petitioner joined the school.
My lord, Mr. Jayanto Samanto on his leg before the court number 38. So
Paramita Malakar.
she is also in that matter. It is a contempt matter in court number 38. Kindly grant short
Both
pass.
are required to stay and one cannot come over here. Huh?
Well, a petitioner joined the service in the year 1997.
Yes.
With postgraduate scale of pay as in normal section as work education teacher. The school got elevated from.
Let your learned friend come. I'm passing it over for the time being.
Grateful.
Next.
I am for the state.
23 for the petitioner.
Permitted to appear on behalf of the my lord, unfortunate mother of the deceased employee, my lord, mother-in-law of the petitioner, my lord, the application for additional.
The unfortunate and the petitioner is not unfortunate.
Both are unfortunate,
Then
my lord.
Why are you all
I have
fighting?
been, my lord, I have been, my lord, driven out by the petitioner, me and my bedridden husband. My lord, I have, my lord, the application for addition of party has been prepared and has been affirmed on last day, my lord. My lord, I am praying for only 1 day accommodation to file it in the, my lord, department.
What? Affidavit in opposition?
No, my lord, addition of party, my lord. An
Application seeking addition of party.
my lord.
Only let me hear what the petitioner has to say.
My lord, on the
Very well.
last occasion, your ladyship would remember on 6/1/2026, paragraph number 3 of your ladyship's order, your ladyship had directed the employee retired on attaining the age of superannuation. Thereafter, he expired. Steps ought to have been taken by the competent authority within the service tenure of the employee. After retirement, the allegation of wrong fixation of pay by the employer ought not have been raised. Thereafter, my lord, a wrong PPO has been issued, which I had challenged, and 3% has been duly deducted from my actual PPO. And thereafter, the total sanction that was done was much lesser. Now, my lord, my contention was that this particular document was tampered. Now, my lord,
Which document?
This PPO, the assessment of the PPO. My lord, kindly take.
Tampered?
Yes, my lord, on the last
What
occasion.
is tampered?
Lord, the DI, my lord, the DI,
Wait.
the DI and the teacher in charge of the school, hand in gloves, have tampered this particular document. My lord, why I am claiming this? If your ladyship kindly comes to page number 110 and 111, which was on the last occasion missing from your ladyship's P7, and I have annexed that as in the form of supplementary affidavit.
Then?
My lord, kindly takes up page number 110 and 111. My lord, serial number 33. Serial number 33 says that on 1st July 2011, the fixation was 28510, 30th June 2012, upgradation in status of school. Because of that upgradation of the status of school, wide memo number 342 of KGP dated 26/3/2015. And even after that, the last heading, the serial number 52, which says my last pay was 1,10,700 on 30th September 2025. This I have got from the official website. My lord would see that the OTP has been confirmed by Debabroto Hait. I was the then TIC, and by the DI of the then DI, Shopon Shamanto. Now, my lord, kindly takes up part D. This document. This is the recent one. My lord, kindly sees serial number 33 and 52 of it. In remarks in paragraph number 33, serial number 33, the memo number is missing in the remarks. This has been digitally tampered in connivance by the DI, in connivance with the headmaster, the now headmaster of the school. My lord would see that the DI, the OTP, yes. And in serial number 52, it is 110700, and it has been it is there. It is 110700.
Which portion are you referring to?
My lord, towards the bottom of the page, page number 111 of P7. My lord, kindly takes up the supplementary affidavit.
Yes.
Supplementary affidavits, serial number 33 and 52.
33 and 52?
Yes. My lord, kindly takes up the remarks in serial number 33.
Yes.
Memo number 342, KGP dated 26/3/2015. It was fixed as 28510.
Right.
Now, my lord, tallies that with this Part D document, which has been later uploaded in that particular website. Now, my lord, takes up serial number 52 in the next page.
Yes.
During the superannuation, my total sanctioned salary was 110,700 on 30th September. Now, my lord, tallies that with serial number 52 of the new Part D.
It has come down.
Yes, my lord.
Ah.
And not only that, it has the hard copies has also been tampered. My lord kindly takes up page number 51 of my writ petition, 51 and 67. These are the original service book and the pension booklet. These hard copies has also been tampered by the DI and in connivance with the headmaster of the school. And during pendency of the writ petition, my lord would kindly see that on 1/7/2025, it was fixed as 110,700. I have signed it while it was in my custody, while I was the headmaster of Bolashini Vivekananda High School. That would see that it is signed on 30th September 2025. During my retirement, this whole pension booklet and the service book was handed over to the DI. And the DI is the custodian after my retirement. It should not go out of the DI's office. This is the hard copy. And in page number 67, it is the pension booklet. 67 of the writ petition. Note sees. It is 110,700. 1B. 110,700. Now, my lord, out of nowhere, they're saying that this was wrongly fixed and they have tampered this particular document after this writ petition was filed. That is the only plausible cause. And 3% has been deducted unethically and illegally. Now, my lord, what I want is, if these two documents are still lying in the DI's office, my lord, I would ask your lordship to get this document before the court and to preserve it. Otherwise, my lord, it will be evident, because if this needs to be changed, they need to be countersigned. The hard copies of it.
You are going in a wrong direction. Yes. Do not go to that extent that they have tampered it. They have merely corrected it after deducting that, because there is a government memo. Right. Do not use those harsh words.
Millard.
There is no malafide intention possibly by the DI against your client who's dead and long gone. Right. Why make these comments?
Millard, there are plausible grounds, Millard. Otherwise, Millard.
Yes, I have followed
there
it.
has been some reason. Otherwise, I would not have gone this hard on the DI. Millard, the reason is this. Millard, after my death, while my pension was pending, Millard, I have died. I have done some RTA applications. I have given repeated representations to them. They have absolutely turned a deaf ear to them. Millard, what happened? Millard, this cannot be changed digitally unless and until the DI calls up the headmaster in the school and both of the
Otherwise, listen, if it is not changed, the pension file will not be ready, and your client, that is the widow, will not get anything, far less the actual amount or the less amount. She'll be left with nothing. This is required to be changed.
Milord, on that ground also I have 5 judgments. Milord would kindly take some.
Please keep your judgments with you. Yes.
My lord, overturn has been overturned condon was.
Yes.
That's why my lord recast as per advice by the my lord DPPG.
Now, is it the 3% that is troubling?
Yes.
The 3%, the memo which was issued later on has been set aside.
Yes. Set aside, my lord.
Then it will go back to the original one.
That's my lord. That's why, my lord.
Where is the fresh cause of action? The widow requires the pension. This is the only issue. There is nothing more.
We have already released the pension. They have, perhaps they are enjoying. My lord, release, my lord. They have not taken.
And no liability certificate. We have received it without prejudice. Without prejudice, we have received it.
Yes.
Because that 3%, my lord.
Yes, that 3%.
Yes. You know, there are judgments of this particular court also of different benches which will show, WP number 15523. The same GO was challenged and it was upheld that whenever, yes, the 3% increment was revoked in term of GO number 292 SL 5S 294/12 dated 22/3/2017 by the School Education Department, the reference of which has been made in altering the pay scale of the deceased. My lord, this will show that this GO was been upheld. My lord, when the school was upgraded from secondary to higher secondary, this GO was issued. My lord, kindly takes up a judgment at a copy to 15523 WP 15523 of 2019.
Since 2011, he enjoyed 3% additional increment.
He is entitled to.
My lord.
But in this writ application, kindly consider here is paying for release of the retirement benefit. Now some dispute raised by my learned friend. But there is a separate cause of action. Kindly consider.
Provision for gratuity minor retired has been released minor but they are now deceased. No liability certificate has been given minor.
Please come.
Malata, only one thing, Malata, the school authority, Malata, the headmaster, teacher in charge. Malata, we have, pursuant to lawsuit, we have issued the no liability certificate. It was sent through post. Malata ask her to collect it. He refused the letter. Over telephone, she was contacted. She also refused to collect the no liability certificate from the school authority. That is one aspect. Secondly, my lord, kindly page 54 once of the writ petition, page 54.
Yes.
This is the service bureau of the petitioner itself, who was the headmaster, the then headmaster. Now, kindly see the remark, verified from leave register and found correct. Devabrata height. The headmaster himself is sanctioning his leave. In law, it is not permissible.
No, at the top. The Chitok Anguli, same page.
That is earlier. That is up to 2020. That is up to 2020. Thereafter, the leave, 107 days leave sanctioned by the headmaster himself. He cannot do so.
Yes,
he cannot sanction his own leave.
Right.
Milord, in this particular petition, I have also enumerated why I had to do it, because I had made several.
There was no teacher in charge, president, and the managing committee was non-functional.
Yes, my lordship.
Then, what will the?
He will send
could
it
have
to
got to the
higher authority, but he cannot.
But then now he's gone.
But I am just.
You cannot.
I am indicating. I am indicating the discrepancy. But we have already issued no liability certificate. I am showing you what his conduct. Not only that.
What can these people do? In the morning, also same thing. There is no managing committee. The retired employee is not getting, cannot make the pension file ready. Same thing.
Yes.
Why is your client not collecting the no liability certificate?
Milord, no liability certificate. Milord, DI, what he has done is, because due to filing of this writ petition, means they are coming down heavily upon me. Each and every place that I am going, Milord, my associates has also personally gone down to them. They are saying, you have filed the writ petition, go and collect it from the school. But I am the widow of the petitioner. Why will I have to collect the no liability certificate from the school? I am entitled to get it from the DI's office.
Wrote 3 letters.
Milord,
all
what
refused.
they have done is they have sent
all
it to the school.
refused.
You have the original over here?
Yes, all refused.
Give it to him.
Milord, it be recorded. I will be collecting it
on. Just to show.
Try to smoothen up things.
But we have already issued no liability certificate. She can collect it and deposit it to them. We have already issued, my lord.
Milord, I have sent them a representation saying, Milord, no liability certificate is being issued to me.
The petitioner forward those envelopes to the court.
No.
And refused December, January, 1st of January and 24th of January. All these are letters. Where is the certificate with you?
No, certificate is with me.
Certificate
I sent the letters to collect it from us.
All right. Is she required to sign over there?
That
For
DI can say that I don't know, my lord.
If the DI can say, then why will the lady go to the school for collection?
I do not know what is the procedure, my lord.
Oblige
I
your
don't know.
lordship.
Perhaps
With school signature, headmistress of the institution, my lord, thereafter DI will issue the certificate.
No, my lord, that is not the case.
Ready, you say?
No, low license certificate already issued. Only the last order.
Issued. Where is the certificate? Did you get the no liability?
No, my lord. They have been saying that I have to go to the school to collect it.
Yes. That's why your letter was sent to her to
Order
collect it.
I have with me. Where is the no liability?
But I have sent them a representation also. I will be telling your lordship the date, my lord, to issue the low liability certificate in favor of me.
আচ্ছা কি বললাম
They will collect
the petitioner is the widow of a deceased employee alleging non-payment of the terminal dues of her deceased husband. Stop. Submission of the petitioner is that the 3% additional increment, which was initially granted to the petitioner on account of, not petitioner, to the teacher, to the headmaster, deceased headmaster, on account of upgradation of the school from the secondary to the higher secondary level, was deducted, and the pension file has been illegally deducted. Full stop. Stop. The learned advocate for the petitioner submits that the deduction is bad and proper calculation ought to be made for releasing the pension in favor of the deceased employee. Stop. Paragraph. It appears that an issue cropped up with the issuance of the no liability certificate. Stop. The certificate has since been made ready, and the school has requested the petitioner to collect the same from the school. Stop. Paragraph. It appears that the petitioner, being a widow, has expressed her inability to visit the school. Stop. The school is accordingly directed to send the no liability certificate to the petitioner through speed post or courier service upon obtaining proper receipt thereof.
last location, no lord.
Within a fortnight from date. Stop. Paragraph. The memo relying on which the 3% additional increment granted to the headmaster of the upgraded school has been upheld by the court. Accordingly, the authority ought not to deduct the additional increment which is payable in favor of the headmaster. Stuff. The pension file of the petitioner is required. Pension file of the deceased teacher is required to be made ready by taking into consideration the 3% additional increment. Stop. the DI shall ensure that the PPO with the correct figure, with the correct calculation, is made ready and disbursed, and the amount mentioned therein is disbursed in favor of the widow at the earliest, but positively within a period of 4 months from the date of communication of this order. Any further issues?
My lord, what I wanted in this writ petition was an interest because it was illegally held up for a longer period of time.
When did your husband die?
My lord, on
October 26th.
October 26th. October 25. 27/10/2025.
And he retired in 2025.
Yes, Sir Lordship.
September, he retired and
Yes.
died in October.
Yes, Sir Lordship.
Then there is not much delay.
Yes.
Acha. The prayer of the petitioner for grant of interest is not allowed for the time being. Stop. It is made clear that if the PPO and the amount mentioned therein is not disbursed within a period of 4 months from date, comma, then the petitioner would be entitled to interest at simple interest at the rate of 6% per annum to be calculated on and from the due date till the date of actual payment. Stop. Acha. The communications made by the school to the petitioner for collecting the no liability certificate, which has been refused to be accepted by the petitioner, filed in court today by the learned advocate representing the school, be retained with the records. 3 envelopes. ওপরে যেটা লিখলাম না, এই যে কি দিয়ে শুরু করলাম, 3 envelopes containing the communications. ঠিক আছে, be written with the records, full stop. আচ্ছা, আর একদম উপরে লিখে দেবেন তো, একটা supplementary affidavit filed by the petitioner in court today be written with the records.
Could the supplementary affidavit copy? But you are not served the copy of the supplementary affidavit.
My lord,
You have the pages, page 101 and 102. You all had it on the last time, if I can remember. These missing pages from the writ petition.
Only missing pages?
Yes,
What are
yes.
supplementary?
Only missing pages, nothing more.
Subject to correction for lordship, my lord, may I get the my lord kind leave of its honorable court, my lord, to file this supplementary, file this my lord application for decision of party, my lord. My lord,
The
kindly,
writ petition is being disposed of.
kindly do not dispose of the writ petition unless, my lord, I will not get anything, my lord.
You have to apply to the DI for
But I have
whatever you
taken
have.
all the concern.
And that is a different cause of action.
My lord, that is why I am, my lord,
It cannot be done in this writ petition. You file a fresh petition instead of a supplementary. ঠিক আছে? Disposed of. Take this back. Judgment
my lord, kindly direct the petitioner, my lord, to disburse the amount in favor of the, my lord, in favor of the mother of the deceased employee, my lord. Kindly direct the petitioner, my lord. Otherwise, my lord, I will not get anything, my lord. Being a helpless lady, my lord. My lord, kindly direct in that effect, my
Cannot be
lord.
done in this petition. Call the next one, please.
My lord, I am WP one side. Adjournment, my lord, I am for the state respondent. Last occasion, there was a direction for filing appraise instructions, my lord.
Then why will the time be extended?
But although I have,
Petitioner retired in October 25.
my lord, yes, my lord.
Then
One instructions to file, my lord, but thereafter, my lord, certain dates are required to be ascertained, my lord. For that, my lord directed me.
why has it not been prepared? 6th and today is the last day of the month.
Understand, it's my fault, my lord.
Your fault.
I could not follow it up. Although I have intimated, I could not follow up, my lord. Look, 1 week adjournment, my lord. Next Friday.
I'll have to make it not today. Nothing. Next.
Lord, I am for the petitioner. My lord. This is the case, my lord. The petitioner was the headmaster.
Line লিখে নিন তো এর আগের মামলাটাতে on the prayer of the learned advocate representing the state respondents. to obtain instruction in the matter. Hearing of the writ petition stands adjourned for the day.
একটা পেজ
আগের দিনে যে appearance থাকবে সেগুলোই লিখে দেবেন 24-এরটা। Yes.
The petitioner is the headmaster, was the headmaster.
একদম বলে নিয়েছে শুধু
Instruction to page. Was the headmaster, he retired from his service on the 31st January 2024. Lord, at the time of before retirement, Lord, he was enjoyed the 3% incremental benefit of the higher secondary from secondary to higher secondary. So what all amount has been deducted. So Lord,
only one report has got. What's the page? Para 5, it is clearly stated that District University School KC Purva Bardhaman wants to inform that the Honorable High Court that the petitioner wrongly enjoyed 2 additional increment for joining the headmaster without any approval of the DI.
Why wrong? Wrongly enjoyed 2 additional increment. Why?
That had been disclosed.
It should have been disclosed. Then?
That has not been disclosed.
So when you received this, you did not see that it has not disclosed. You should have followed it up.
25.
The matter has been clarified as well.
Just he just cited the Geo and that 2 Geos only.
Yes. So did you go through the Geo? The Geos are annexed over here.
We already have annexed 181, Lord. Page para 4B.
Yes. Please come. Report filed by the District Inspector of Schools, Secondary Education, Purva Bardhaman. Signed on 25th of February 2026. Be written with the records. Stop. The
Yes, 35, it was approved by the DI.
Past fixation, rightly approved.
Variety are also disclosed. At the time of scrutiny of the DI Shweshwar, the Deputy Director of Purva Bardhaman had found that the petitioner had enjoyed the extra increments. As per that very Geo.
Let a copy of the report be handed over to the learned advocate for the petitioner. Stop. It will be open for the petitioner to file exception to the report. Within a period of 3 weeks. Stop. List the matter in the combined monthly list of April 2026. Next.
Just now, also hand it over.
Yes.
Let me record it. Close.
26, my lord, I am for the petition.
I am happy with the statement.
The case of the petitioner, my lord, from 2002 to 2019, an arrear claim amounting to rupees 1,79,000 was due and payable, and it has been calculated by the school authority and said, but there are some pro forma mistakes. Accordingly, my lord, in 2021, again, my lord, this pro forma it is continuing from page 9 and page 10 onwards, my lord. This bill was given. Again, my lord, I made a representation on, my lord, 2025, 2023, my lord, 2nd November 2023, that this amount, 1,79,000 has not been paid to me. In the meantime, I retired, my lord. I am only praying, my lord, let my representation be considered, and whatever, my lord, the steps should be taken.
Where is the last representation?
My lord, page 31. My lord, I have been told, my lord, certain documents is needed.
My instruction is that the school authority sent the payer of the petitioner, my lord, to the DI without any enclosure, my lord.
What?
That is why, my lord, on 8th February, DI wrote a letter to the school authority.
This year?
Yes, my lord, 8th February 24.
24?
paragraph 2, my lord, without an
Please come. The petitioner is a retired assistant teacher of a school. He alleges that his arrear claim amounting to rupees 1,78,493 for the period 1st August 2002 to 31st of November 2019 is due and payable. The petitioner submitted repeated representations before the school, but the same has not been taken up for consideration.
DI and Commissioner of School Education.
আচ্ছা স্কুল যেখানে বললেন সাবমিটেড বিফোর দি রেসপন্ডেন্ট অথরিটিস করুন ঠিক আছে prayer has been made to direct the district inspector of schools to consider the prayer of the petitioner for releasing his arrear claim. Learned advocate representing the district inspector of schools, secondary education, Purbo Medinipur, relies upon submits on instruction that the school authority submitted the arrear claim of the petitioner in the office of the ADI within bracket SE Contai subdivision without enclosing necessary papers in favor of the claim. The ADI with a communicating letter dated 8th February 2024 requested the school to submit the wanting documents. The same has not been supplied by the school till date.
wanting documents in next page, my lord.
The documents which are required were also intimated to the school authority.
As well as
Copy
petitioner.
of the school authority with a copy marked to the petitioner.
I have not reached.
A copy of the communication dated 8th February 2024 is handed over to the learned advocate for the petitioner in court today. Paragraph, the school is not represented. In view, now, as the petitioner has already retired from service on
30th November 2019.
30th of November 2019, accordingly, the court grants leave to the petitioner to forward the requisite documents as mentioned in the communicating letter dated 8th February 2024. To the district inspector of schools for consideration of his claim for releasing arrear payment. The claim of the petitioner shall be considered in accordance with law, and if the same is found due, the then necessary steps for releasing the same shall be taken without any delay. Steps shall be taken by the District Inspector of Schools within schools at the earliest,
This
but
one number 5.
positively within a period of 8 weeks from the date of receipt of all documents from the petitioner.
Grateful. Respond number
If
5.
the prayer of the petitioner is not found to be acceptable, the same shall be communicated to the petitioner with supporting reasons. Disposed.
Well, respond number 5, my lord.
DI বলে দিই।
SC পূর্ব মেদিনীপুর।
DI বলে দিই।
ADI or DI?
DI, my lord.
DIs. All right.
Great.
আমারটাও দিয়েছি।
I'm a state respondent.
Revised gratuity and ADR pension order. Petitioner retired on
2018.
retired on 31st May 2018, and revised PPA issued on 7th October 2020, and your petitioner received 11th November 2020. Similar order has been passed by your lordship in earlier occasion in another matter. My lord. I have
And the dates are correctly mentioned?
Yes, madam.
The dates are correctly mentioned?
madam.
Team order. A correction school of the Disposed.
Grateful.
Not 28. 28, this matter relates to second listed on question matter, lordship. It will be released after 23rd March, lordship. Appeal is pending before the revision bench.
Lordship, I am for the secondary board, lordship. Learned advocate appearing for the petitioners. Praise for posting the matter after 23rd March 2026 on the ground that the issue in question is pending consideration before the Honorable Division Bench. Stop. On such prayer, list the matter on 30th of March.
Under 29. 29.
29 lakh.
Yes, this is 29.
See, my lord, the petitioner, my lord, appeared, my lord, in the second SLST, my lord, for assistant teacher, post of assistant teacher, under, my lord, 11 and 12. My lord, he appeared in service category, my lord, because he had been, my lord, teaching in the school as well as working there. My lord, for long 15 years. And the, my lord, application form was filled up showing his, my lord, service there. But, my lord, annexer P9 at page 35, it appears that there is no such marks on experience category. Your lordship will be pleased to see page 35. Experience score 0. That's why I have made the representation to the authority concerned.
Show me your application form.
My lord.
Show me your application form.
Application form.
It is not annexed with the petition.
All right. Assuming you get 10 marks on account of experience, even then you reach 70 and you do not reach the cutoff of 73. Why will the audit petition be allowed?
The representation has been made to the concerned authority for taking a decision in respect of that, my lord.
I assume they give you 10 marks. Even then you do not reach the cutoff. What happens?
Marks may be given, my lord, awarded to that. That's why the experience. For the
even if 10 marks is awarded, how much do you get?
30, 70.
70. The cutoff is 73.
On my lord, page 73.
Page 35, I can see 73 is the cutoff. Then you do not reach the cutoff. So no use. Please come.
My lord, your lordship, my lord, that marks may be awarded, and to that effect, my lord, that should be correct. For the purpose of.
The petitioner participated in second SLST 2025.
That has been supplementary affidavit, my lord.
Allegation is that marks on account of prior teaching experience have not been awarded, despite the petitioner being an in-service candidate and is in service for more than 13 years. Where is your application form?
Application form could not be annexed, my lord.
Why?
The admit card is there, my lord.
Your admit card will not show. Application form shows whether you have filled in the column for the prior teaching experience.
That filled up by the
show. Acha. ঠিক আছে.
I have stated in the application. Also.
The application form of the petitioner is not annexed to the writ petition. Stop. There is nothing on record to suggest that the petitioner filled up his experience in the application form. Stop. On a perusal of the result details in respect of the subject concerned, it appears that the petitioner secured 60 marks and the cutoff in the said subject is 73. Stop. Assuming that the maximum marks on account of experience, that is 10 marks, is awarded to the petitioner, comma, even then he he will not reach the cutoff. Stop. Next. In view of the above, the court is not inclined to exercise jurisdiction in the matter. The writ petition fails and is hereby dismissed. Affidavit of service and the supplementary affidavit filed in court be written with the record. What is the supplementary?
My lord, the experience certificate annexing, my lord, there, that I have been working there.
Your application form is not there. Okay, later. You are working as clerk.
On demand of the PEA.
You are working as clerk.
Clerk as well as teaching in the school in need of the school. That's why the committee.
I do not follow. How does a clerk teach in a school?
My lord, pursuant to the the permission as well as the permission of the DI, I have been teaching there. In
now
addition
the
to that,
service of the DI will be terminated. I am wondering what is going to happen to the students who are being taught by a clerk.
English. Teaching experience MA in English.
It appears from the
having MA English, my lord, I have been teaching there.
MA in English, working as a clerk.
Prior to my lord appointment, I have opted that qualification.
Answer. The petitioner has annexed a certificate issued by the assistant headmaster cum teacher in charge of the school, certifying that the petitioner is working in the institution since 2012 as a clerk and has been imparting educational lessons. Stop. The court fails to comprehend as to how the school could permit a clerk to take educational classes of the students of this school.
Well, page 32. You
anyway, it's dismissed. Sorry.
Page 32.
Next.
I am appearing with Mr. Joydeep Banerjee in this matter for the state lordship.
It is your name that will go down.
Rajaram Banerjee.
Yes, next. Yes, 30. Yes.
I am appearing on behalf of state.
Participated in the 2025 SLSTs.
How many are there? 14?
14 petitioners.
I have given the deficit court fees. Petitioner participated as a fresher candidate. So, my lord, your lordship knows very well they are not getting the 10 marks. My lord, they have only 1 marks is the shortfall in the cut-off marks. Kindly see page.
So what can be done if the candidate...
one question is wrongly assessed by the School Service Commission that I have challenged, my lord. My lord, if the School Service Commission giving them the 1 marks for that reason, my lord,
for all candidates, 1 mark short.
1 mark short.
So you segregate the candidate with 1 mark short and file
no,
one.
they are good candidate. They have come. That's why. Because if the
The petitioners participated in second SLST 2025 stuff. They are 1 mark short than the cutoff stuff. They allege that their answers have been wrongly assessed by the commission. Stuff. Paragraph. They pray for a direction upon the commission to, what is your prayer? To allot marks to the candidates upon reassessment of their answers. Up next. The issue in question as to whether there is any scope for passing order for reassessment of the questions after publication of the final answer key is pending consideration before the Honorable Division Bench. Stuff. In view of the above, hearing of the writ petition stands adjourned till 30th of March 2026. Stop, liberty to mention.
the deficit court fee and affidavit service.
The receipt showing payment of deficit court fees and the affidavit of service filed in court be written with the records.
The prayer is at page 15. WhatsApp করে দাও, WhatsApp করে দাও, WhatsApp করে দাও।
I want to respond.
হ্যাঁ, ঠিক আছে, একটু
31 also,
জায়গা
same issue 2 marks shortfall.
Solve segregation. Till how far will you go? 1 and 2 and then 3 and 4.
Yes, my lord.
At the same finish. 2 marks short. Deficit court fees and the affidavit of service.
এটা দেবকুমার মাইতি দিদি না 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 দিস না, বারণ করছে যে যে নেই তার নাম না লিখে কোন নামটা কেটে দে
33.
না
30 malady in two question, malady and 2 marks, malady.
32. 2 marks.
Cut off marks 33, we got malady 61.
Cut off marks?
63. I got malady 61.
61. All right, 2 marks short. Deficit court fees and the affidavit of service. Animesh Babu.
এবারে হচ্ছে নরেন বসাক
Malady, I have challenged 3 question. Malady, I got malady 61, cut off marks 64, 3 marks.
So it's coming gradually.
They have come in group A because malady others similar issue. That's why malady file in the.
All right, 3 marks short.
Get. Yes.
আমরা না কিরকম এদিক ওদিক সেকেট করছি
Affidavit service and court. Get.
এটা পাঠানা শ্রীরাম মন্ডল 3377 নামগুলো কার
Appearance.
সব নাম কার রাহুল কাট কাট একটু দিন
And thereafter, my lord, Gram Panchayat issued a certificate to the petitioner that petitioner belongs to Chashi community and it is an OBC.
Gram Panchayat issued certificate.
My lord, kindly
Page
sit.
number
Yes,
16.
what happened? So, in consonance with that, I filled up that OBCA application. My OBC status, my lord, is not. SDO subsequently said that no, that community is, you do not belong to that community, belong to some other community, and that community is OBCB and issued me a OBCB certificate. And my lord, accordingly, my lord, in 910, since I filled up as an OBCA, the verification stage has not yet been called. My lord, I want to change because it is not my fault that I have did this.
No, but then how could you fill in your application form relying only on the certificate of the Pradhan of the Gram Panchayat?
Previously.
The certificate of the SDO is the authentic one.
Yes, my lord, but previously, my lord,
page 69, I
Yes.
was an OBCA.
Did you ever have a certificate issued by the SDO?
No, SDO did not issue me a certificate. Kindly
you
come
do
to
not fall within the, you do not come within the 21st July 2025 date. How will you
My
get
lord,
the benefit
kindly
of
see-
reservation?
My lord, kindly come to page 39 once.
Yes, 39.
Page 14 থেকে
My lord, this is category OBCA. I have applied.
How do you say you
Based
are
on the
OBC?
panchayat.
Sorry, sir.
My lord, kindly come to page 69 once.
I have come to page 69.
My lord, it says this.
So, panchayat certificate is not a proper one. Please come. The petitioner seeks reservation. Now, the petitioner participated in second SLST 2025, mentioning himself to be a member of the reserved category -OBC caps A, relying on a certificate issued by the Pradhan of the Gram Panchayat on 11th of August 2025. Stop.
My lord, only one thing, previously, the community which I belong was, I did not have a certificate, but that community was regarded as an OBCA.
Is that an effective consideration, you please say? That is never an effective consideration. ঠিক আছে?
It is not there in Sartak most probably. নেই না, তাহলে বলছি কার্তকে যদি না থাকে তাহলে বলছি যে অন্য দিন বলছি চেষ্টা করছি।
Where is your SDO certificate?
My lord, SDO certificate is at page, my lord, 71.
The petitioner has thereafter been issued a reservation certificate by the subdivisional officer on 16th of October 2025.
Thank you.
Mentioning that he belongs to the OBC-B category. Stop. The petitioner seeks the benefit of reservation. It has been submitted that the petitioner was that the community in which the petitioner belongs previously belonged to the OBCA category.
Yes, yes.
And thereafter the same got changed to the OBC-B category. The petitioner is no way responsible for such change, and the benefit of reservation ought to be given to him. On a perusal of the documents annexed to the writ petition, it appears that the petitioner applied for participating in the recruitment process on 10th July 2025. On that date, the petitioner did not have any reservation certificate in his favor. Stop. The reservation certificates relied upon by the petitioner, issued by the Pradhan and the SDO, are dated 11th August 25 and 16th October 2025 respectively. Stop. The commission has disclosed its stand that any certificate issued after 21st of July 2025 seeking reservation will not be accepted. In view of the above, the last date for filing the application form was 25th of July 2025. Paragraph. In view of the above, the prayer of the petitioner seeking reservation relying on certificates issued after 21st of July 2025 cannot be accepted. The writ petition fails and is hereby dismissed. Date service is taken on record.
না এবার হচ্ছে 35
My lord, I am for the petitioner.
My lord, I beg to appear on behalf of the state. I am led by
Yes.
Mr. Rajat Dotto. He is in courtroom number 15, my lord. My lord, due to my illness, I am appearing through VC.
Yes, yes.
My lord, kindly come to page 39.
39.
My lord, here I applied as an OBC A.
Yes.
My lord, previously I was OBC B. My lord, that is at page page 70, my lord. This was my previous certificate. But my lord, on 10th of June, your lordship knows that previous certificates were all set aside, my lord, and a new survey was conducted. And on 10th of June, my lord, the government published a new, my lord, notification saying that which caste has been what. My lord, according to that 10th June, kindly come to page, my lord, 45. My lord, kindly note the caste of page 70 first. I belong to Tat.
Yes.
Tati. Now, my lord, page 45. Kindly see Tati, my lord, serial number 7. It has been now regarded as OBCA. Since it was published on 10th of June, my lord, my caste, my lord, I applied as an OBCA. Because, my lord, here.
Yes, thereafter
Thereafter, my
options
lord.
provided to you to edit.
Yes, my lord. Now.
Did you?
My lord, why I cannot, my lord, that is at page, my lord, 75.
Where is your certificate? New certificate has been issued or not?
Yes, 75.
75.
Kindly see the date. My lord, certificate is only a recognition of the fact that I am an OBC. Certificate, my lord, cannot say that I am. The Gazette notification only recognizes I am an OBC. Certificate is a recognition of that.
Yes.
My lord, page 75, kindly sees the date. So, when the edit option was given, my lord, I applied as an OBC. It's not that I have to edit my option. Since I applied as an OBCA pursuant to 10th June, I applied as an OBC. So, my lord, the option of editing does not arise, my lord. But since this is 11-12, my lord, in the waiting list, I am in the waiting list. I have been placed as a general candidate. Since, my lord, at the time when the verification was conducted, I could not produce the certificate at page 75. I only produced the 10th June notification.
When did the verification take place?
Verification take place in December, first week of December. Before this, my lord. Results were published in 14th of November. Verification took place in the first week of December. Before I got the certificate.
All right. Yes.
And my lord, page 74, kindly see, I have been placed in the waiting list. As a general category.
How much did you score? You are Shubhankar Das. Where is your...
My lord, Shubhankar.
Yes, you scored 74.75.
Yes, my lord, 70.
What is the cutoff in the schedule category?
OBC category, my lord.
OBC.
My lord, that, my lord, I cannot. 35. So 35 item number. Oh, এইখানে দেখছি। My lord, serial number 22.
I have seen serial 74.75.
Yes. This is, I have come as a general, my lord.
Yes.
She was called for verification as OBCB. We had result. 71.
Relying on page number 71.
Yes, that is my case. My lord, page 71, I was called as an OBCA for verification. That is my case. But since I only showed the Gazette notification of 10th June and could not produce the certificate, my lord, that is why I have been placed in general.
My lord, he could not show that he was an OBCB as
OBCB?
OBCB, OBCA.
OBCA.
Verification date was 29th November.
29th November, my lord. I'm relying on page 71.
Yes.
The verification date is 29th November 2025.
Listen, the candidate does have an OBC A category certificate. It is page 75. And for some reason, he mistakenly filled in his application form as OBC A because he had an OBC B certificate at that point of time. Right? But on the date of the verification, the category got changed.
My lord, at page 75, my lord, kindly just.
But only one thing, at the time of filling up the application form, I was OBCA pursuant to 10th June notification.
Oh, you were OBC?
Yes. It is not a mistake that I've correctly
Alright,
filled up
10th June notification, he is OBCA, and now what can be done if the certificate is issued later on and because of the certificate?
16 December the certificate.
My lord, the date of the certificate is 16 December 2025, my lord.
But then he belongs to the category, not that he doesn't belong to the category.
Verification, if the candidate is not able to show, my lord, then we are unable to proceed, my lord.
It cannot be helped. The candidate is OBC candidate, whether A or B or whatever. The notification came in. Is it your case that the 10th of June, the candidate had the certificate? He could not have because the notification was issued on the 10th.
My lord, page 44.
The notification was issued on the 10th and he could not have had that certificate on that date.
He did not apply for that. Look, from 30th July, the portal was open for new application. More than 1,12,000 candidates applied for that new certificate. They obtained that new certificate and they appeared with that new certificate. On the date of his verification on 29th of November, look, he has to produce his current certificate as per his claim in the application form.
When did you apply for the new certificate?
He has not disclosed when he had applied.
My lord, kindly see, my lord, notification of the SSC, point number 2.
No, when did
you apply, you say?
When did you apply?
He has to produce the certificate during verification.
My lord, what is the, my lord, what is the function of a certificate, my lord?
This function of a certificate, the court is aware. You tell me, when did you apply?
My lord, I applied, I must have applied, my lord, before.
Is anything mentioned in this 10th June as to when an application is to be made or anything?
My lord, this is
There
the
no end
application
point of
of
making an application.
communities which are regarded, this notification only, my lord, envisage the communities which are regarded as OBC more backward or backward. My lord.
Yes.
So according to this notification, my lord, initially I was backward OBCB, but after this I am regarded as, my community is regarded as more backward. So OBC, after this notification, my lord, I could not have applied as an OBCB. My lord, I applied as an OBCA. At the time of verification, my lord, when they wanted my certificate, I showed this notification that I am an OBCBA, this is my community. So I am an OBCA. My certificate has not been handed over to me. And my lord, that is why at the final, when they finally published the list, my lord, I was regarded as a general candidate. My lord, only thing is to be ascertained whether I
When
have.
was the application made?
My lord, I am just taking instruction. My lord, there was no such date mentioned that one has to apply within this 30th of July or.
But my lord,
Because, my lord, I tell your lordship, on 16th of June, there was a stay of the High Court of this notification. Thereafter, my lord, the Honorable Supreme Court said that you can proceed. Thereafter, my lord, they again proceeded. So it's not that within 21st July I can apply. Because the.
my lord, there were edit windows which my lord is aware of. What is being submitted is perhaps not right. And my lord, he's not being able to show when he had applied for it because the Oscar portal was open from the 1st of August.
Yes, my lord, 1st of August it opened. So after, see, it is after 21st July.
There were several edit windows after August also.
My lord,
1st of
edit
August.
windows is not applicable because edit windows are only applicable for those, my lord, who filled up as unreserved. Subsequently, for edit option, they.
If is there any mistake, then the edit window comes in. Otherwise,
did
there's
not
no
commit
question
any
of an edit
mistake.
window.
Yes.
I do not have an OBC certificate as I am a new entrant. My OBC category has changed. My certificate is an old. If you have an old certificate, enter that number for future reference and verification. If you are a new entrant and do not have a certificate, leave the field blank.
My lord, kindly come to page 39. Why I say they regarded me as an OBCA? Kindly come to page 39 once. My lord, kindly come to page 39. Your lordship has seen category and subcategory.
Yes.
My lord, this is, we cannot, my lord, this is not manually filled, this is auto-generated. My lord, immediately when I put my subcategory, the option comes at OBCA. So it is not, my lord, that I will put this. So in their record also, this is recorded as OBCA, and that is why my option was given as OBCA. My lord, if I have secured the above the cutoff in OBCA, I should be considered as OBCA.
What is the cutoff?
My lord, that I do not, since I have not been. My lord, they can say.
56.
Page number 70.
No, after page number, my lord, 71, I was considered as an OBCA and a call for interview.
So that means candidate has got more than the cutoff.
Yes.
During verification, we did not show that.
I understand, but then I think this benefit ought to be given to the petitioner. Anything to show when you applied?
My lord, I applied in the month of November. Date, exact date, my lord, my client could not say, in the month of November.
Well, my lord, he was not called for interview.
No, I am in the waiting list.
Oh, as a general candidate.
As a general candidate, yes.
As a general candidate.
Waiting list as a general candidate.
Accepted, he appeared for interview as general candidate.
My lord, may I make one humble submission?
Yes, please.
Before the notification of May 2025, he was a OBC B candidate. He should have that certificate at that before while making application as a OBC B certificate. He should, at the time of verification, he should have produced that certificate along with the notification that yes, I was a OBC B, but by the dint of this notification, I have become OBCA. That should have been shown by him at the time of verification.
I wish you could have advised the commission how to act. I wish. Yes.
But he appeared in the interview as a general candidate.
No.
I do not have a board over here to show whether I am a general or a reserved category candidate.
But he has to, during the verification, has to show some document, my lord. That is in our rules.
Did you have the OBCP certificate when he applied? He was in a reserved category earlier.
My lord.
Because of the June notification, his category changed. He may have applied later on. What is the problem? You can treat the candidate as a reserved category candidate because he has right now produced the certificate.
Well, it then kindly allows us to come back on affidavits. We want to deal with this, my lord.
Please come.
You have to substantiate Rule 11A.
The petitioner applied in second SLST 2025 as OBC A category candidate by disclosing his subcategory as Tati, Tontubai. Page number 39.
11, my lord.
The petitioner applied bolam data 29th of June 2025 stuff. The petitioner had a reservation certificate in his favor in the OBC B category. issued by the subdivisional officer in the year 2015. Stop. After publication of the notification on 10th June 2025, the subcategory of the petitioner was found to be incorporated in the list of OBC B category.
OBC A category.
আচ্ছা, A category. ঠিক আছে? The as on the date of making the application, comma, the notification specified the petitioner to be in the OBC A category, comma, application was filled accordingly. Stop. The candidature of the petitioner was considered as OBC A category, and from the result details annexed to the writ petition, it appears that the petitioner secured 57 marks, whereas the cutoff in the subject category is 56. Stop. At 57 and 56. The petitioner obtained the OBC A certificate in December 2025. Stop. As on the date of verification, the petitioner was unable to produce the reservation certificate in the OBC A category, comma, the authority considered the candidature of the petitioner in the general category. Stop. The petitioner is aggrieved by the same. Stop. It has been submitted that the petitioner did belong to the reserved category on and from the date of his birth. Stop. He possessed the OBC B category certificate till the issuance of the fresh certificate in the OBC A category. Stop. The subcategory of the petitioner stood changed from OBC B to OBC A only in June 2025. Stop. Prayer has been made to grant the benefit of reservation to the petitioner. Stop. Learned advocate representing the commission opposes the prayer of the petitioner. Stop. It has been submitted that on the date of verification, the petitioner was unable to produce any document. আচ্ছা, ভেরিফিকেশনের ডেট হচ্ছে 29th of November 2025. The petitioner was unable to produce any certificate of reservation in the OBC A category. Stop. The petitioner has been treated as a general category candidate. Stop. Paragraph. Though the court is of the prima facie view that as the petitioner all along belonged to the other backward classes category and did possess a reservation certificate in his favor in the OBC B category, and his caste detail in the and his caste detail has been included in the A category in June 25, the petitioner could not have mentioned, disclosed his caste in the earlier category. Stop. He rightly disclosed his category as OBC A in the application made on 29th of June 2025. Stop. the edit options provided by the commission had to be applied only if there is a change in the category detail of the candidate. Stuff. In the instant case, the category detail of the candidate did not change, but the petitioner failed to produce the OBC A category certificate on the date of verification. Stop. The same does not imply that the reservation of the petitioner stands extinguished and he can be treated as a general category candidate. Stop. Nevertheless, as the commission seeks to revert with a report disclosing its stand, accordingly, hearing of the writ petition stands adjourned for the time being. Stop. Let the report by way of an affidavit be prepared and circulated within a period of how soon? 2 weeks. Reply, if any, within a week thereafter. Stop. List the matter immediately on completion of the aforesaid time period. Stop. The candidature of the petitioner in the reserved category shall abide by the result of the writ petition.
Great.
My lord, I have given my name in the chat box.
Yes, please. Appearance to be recorded.
My lord,
Call the Passover matter.
My lord, only one thing, my lord. Item 36 to 41, your lordship knows these are SLST matters, my lord, challenging the rule and time of. My lord, since your lordship only, my learned friend is also here, my lord, since your lordship has extensively heard it, only commission submission is remaining and part of state submission. My lord, can it be make it part heard? Because we will be in great difficulty, my lord.
Assuming I make it part heard, there is a note in the list which mentions that immediately on change of determination, the part heard goes. If you want the matter to be retained by the bench, you have to obtain order from the Chief Justice assigning. It is all yours.
My lord, subject to that I can do, my lord.
Then-
Subject to correction, my lord. There has been a subsequent that to reduce the, my lord, difficulty of the learned
Show me
advocates,
that
my lord.
one.
That notification. There is
Show me that notification.
monthly list, my lord.
Where is that notification? Find it out and come at 2 o'clock. I'll see. Because next week also, possibly the bench will be here.
You will be here because my
Right.
lord is
In circuit.
inside.
All right. So you please show me. I'll
Fine.
see what is to be done. Yes, Passover matter.
My lord, I am appearing for the petitioner. My lord, I ask to Mr. Pro, my lord, Shantanu Mitro, my lord, appearing for the SSC. As
I am
he-
for state led by Mr. Bihani.
State.
I am for state led by Mr. Bihani.
So he's there.
Yes, my lord. SSC is the answering respondent.
SSC is the
Commission-
answer.
Yes, Lordship Commission is answering.
What is it? An SLST matter?
No, my lord.
What matter is this?
First SLST upper primary 2015, my lord.
Then Mr. Patro possibly will be appearing.
Yes, yes, my lord. I also, my lord.
Then in that case, I'll make it not today.
My lord.
Yes, call the next part of Passover.
Sorry, my lord, I stuck. My lord,
Keep your juniors ready. I told you earlier also.
my lord, he was on the another court also, my lord, in containment. My lord, before learned friend start, my lord, may I indicate one thing, my lord? On the last occasion when the matter was heard, your lordship was pleased to indicate the Tarak Karan judgment. I file Utpal Karan and Tarak, my lord, Roy. I have brought two judgments, my lord. In view of that judgment, he is not entitled to.
Which judgment he's not entitled to?
Utpal Ganti Karan.
He's not entitled.
No.
And in Tarok Roy, will it be?
Tarak has been considered here, my lord.
Yes.
Even he is not entitled. My lord,
Entitled. This is a 2010 matter.
no, he entered into service in
The
1997.
petition is of 2010.
2010.
Then I'll post it for hearing if it is cannot be
No, my lord, in view of the judgment, my lord, kindly consider para 130. My lord,
No, the judgment is here, no issues. What is,
my lord, kindly consider para 184.
now what is there? Please mention.
A teacher who has entered service in the postgraduate category shall not be entitled to higher scale of pay merely because he has acquired higher qualification subsequent thereto or prior to his appointment. Here, my lord, he obtained prior to his appointment. He has been asked by the school to perform his duty in some of the classes in higher secondary section, and that's why he is asking for higher scale.
The case is, may I represent
This has to be heard. It cannot be done now.
2 p.m.?
2 p.m. I've got other matters fixed.
The difficulty is tomorrow the petitioner is getting super.
So what? How does it matter?
No, if something is written, that the terminal benefit will not be stalled for the pendency of this writ petition,
Cannot.
because your lordship will not have the jurisdiction.
Some honorable judge will have the jurisdiction.
That is, but tomorrow he will retire.
Yes. Please come.
There will be some
The
impediment.
petitioner seeks higher scale of pay. Stop. He is due to retire from service tomorrow. That is 28th of February 2026. Stop. The matter is required to be heard. Stop. Be it recorded that pendency of the writ petition will not stand in the way of the respondents to make the pension file of the petitioner ready in accordance with his admissible scale of pay. Stop. List the matter for hearing in the combined list of March 2026.
Grateful.
1 p.m. matter.
Lordship, in this matter, I appear for the added private response.
Lordship, I am for the petition.
Yes.
I'm for the response. Lordship, the petitioner herein is claiming family pension, disbursement of family pension of the deceased employee.
Who are you?
I'm the wife. I'm the legally married wife.
First, second, third.
Hindu.
How many could you marry? You are a Hindu, so you could have married only once.
Yes.
You could not have any other
I'm the
wife.
wife, Lordship. I am
Yes.
first and the only married wife.
All right. The other wife is how she gets the status of a wife.
Lordship, I'm coming to that. Lordship, kindly come to the PPO.
Page.
Page 27. And the relevant portion is as 32.
32.
Shibani Nag, Lordship. The first name. Wife, 55 years old.
Yes.
Now, date of birth. Kindly note the date of birth, Lordship.
Whose?
The wife, Shibani Nag.
All right.
Below the age, the date of birth is given, Lordship.
Yes, yes.
Below the age, the date of birth is given.
Yes.
Now kindly come to page 18, Lordship. The marriage certificate.
Date of solemnization. Date of solemnization.
Date of solemnization is 10/8/1974.
Yes. What is happening?
Oh my God.
সায়ন ভূমিকম্প হচ্ছে রিকুকে ধরো
Why so many people over here?
Supplementary list, my lord.
Huh?
Supplementary.
Oh, supplementary. Wait, I was in the midst of a matter.
Oh. এটা কন্টিনিউ করবি চলে যাই বললো কতক্ষণ নেবে কতক্ষণ লাগবে তো বললো চলে যাবো না না বেশিক্ষণ লাগবে না।
Are you there in 2? Item 2? Yes.
Lordship, may I start from start?
No, please don't go back. Again, it will start trembling.
Lordship, before your Lordship hears of the petitioner, I just want to take 1 minute, Lordship. I am the added respondent number 5. I was added by this honorable court. I was not made a party earlier. I claim to be the real wife and I have submitted all the documents and I've also given a opposition to my learned friend's petition. So this question is wide open. And Lordship, this is not maintainable here. How can the writ court
Lordship.
decide who is the real wife?
All right.
Lordship, it is. May I kindly place the facts?
You are placing the certificate at page 18.
Lordship, the marriage registry certificate, page 18, Lordship. Kindly, Lordship, note the date of the solemnization, 10/8/1974. And here the respondent number 5 is claiming that she was married to the deceased employee 1976.
Right.
Now, kindly come to the Lordship opposition of the KPT. KOPT.
What does it say?
Lordship, kindly come to page number 14.
I married in 1976. আরো কয়েক years
Into registration.
আরো registration
Since the alleged wife, that is the private respondent, had
Page 14,
page 14, Lordship.
23rd of May 2011.
Lordship.
আরে registry
Yes. Verification of the personal identity of Shivani Nag.
Because there was a discrepancy. As the private respondent, the respondent number 5 claimed for family pension before.
You claimed.
Yes, Lordship.
All right then. When did the employee die?
Employee died 2010.
21st October 2010.
21st October 2010.
And respondent number 5 claimed
nomination গেছিল
the family pension in 2011. And the petitioner claimed in 2013, Lordship.
You knew that your husband died?
Lordship, I knew my husband died and I was in a remote state, and as I am an illiterate person, I was not aware how to make the application and all. That is why.
So your husband didn't stay with you. He stayed separately with the private respondent.
Lordship.
But the marriage took place with you.
Lordship.
What is to be done now? Your husband has created all problem by marrying so many people. What is to be done? What can the writ court do and what can the KOPT do?
Lordship, one thing I would like to submit, that there are discrepancy in the fact that is stated by the respondent number 5.
All right. Please come.
Kindly.
The petitioner claims to be the legally married wife of the deceased employee of Kolkata Port Trust. Stop. The employee retired from service on 1st January 2004. How can it be 1st of January? 31st December, whatever, who separated from this trustee's service on, anyway, 1st of January 2004 and died on 21st of October 2010. The petitioner claims that she ought to be paid the terminal dues of her deceased husband. Stop. Paragraph. The private respondent number 5 also claims to be the wife of the deceased employee. Stop. Kolkata Port Trust conducted an inquiry and found that
The police
the
verification, Lordship.
conducted inquiry through the police, where
Lordship, one
wherein it was revealed that the photo of the lady appearing in the pension file is not of the legally married wife of the employee.
Lordship, the photo is of the petitioner, Lordship.
All right. The marriage with the lady with which the petitioner, with which the employee was staying, was not registered. The character of the pensioner was not good, and he had extramarital relationship with other ladies. Achha. The service book of the employee records the name of the petitioner as his wife. Stop. Paragraph.
The date of birth also.
As it now, the photograph of the petitioner is annexed in the service record of the employee. Stop. Paragraph. As it appears that there is a discrepancy with regard to the legally married wife of the employee, the said dispute cannot be adjudicated either by the writ court or the Kolkata Port Trust. Stuff. Next. In view of the above, no relief can be granted to the petitioner in the instant case. Stop. The writ petition fails and is hereby dismissed. Stop. Dismissal of the writ petition will, however, not stand in the way of the petitioner from approaching the competent forum for declaration of her status as the legally married wife of the deceased employee.
My lord, my lord, I am appearing for respondent number 5 and led by Mr. Indranil Chakraborty, my lord. Due to some physical issue, I am not able to appear today in court.
All right.
May my appearance be recorded, my lord.
It is very short issue. Acha dekhi.
Lordship.
Your lordships directed me to take instruction from it.
Last 3 paragraph number 10.
Yes.
My lord, petitioner has relied, my lord, page 84.
Yes, 80.
Page 84. Your lordships directed me to take instruction whether they are the similarly situated petitioner or not. They are not the similarly situated with the petitioner. However, commission, my lord,
has identified a vacancy.
No, my lord.
No.
My lord, in the present case, my lord, petitioner was re-recommended to a school which are far away from his residence.
I understand. Now, in that case, a petitioner has to file fresh
transfer application and my lord, commission will
consider it
accordingly, my lord.
Please come.
Since my lord, petitioner is suffering, my lord,
Forwarded by the chairman of the West Bengal Central School Service Commission, dated 26th February 2026. Handed over in court today, it's taken on record. Stop. It appears therefrom that the petitioner is not similarly situated as the teachers mentioned in Page 84 of the writ petition. Stop. The petitioner seeks transfer on medical ground. Stop. It will be open for the petitioner to make fresh application যেটা আছে না medical ground এ সেটা করে দিয়ে দেবেন. Disposed.
Such application is being the process within time bound.
Yes, yes.
8 weeks এর মধ্যে করতে হবে।
Yes. Urgent motion. Supplementary? Yes. Supplementary list? Yes, please.
A very short issue, Millard. And will kindly comes to Millard page 26, annexure P1. Petitioner is a Millard, college Millard, imparting Millard, D Pharma education. Started from Millard, August 2022. Page 26 is the initial consent letter by Millard, the State Council. For the session Millard, 22-23. Subsequently Millard, page 27. Affiliation by the PCI for the session 23-24. I mean, once again, Millard, I renewed my affiliation. Next page, page 22, by the State Council for the session 24-25. Accordingly, Millard, the PCIA has also Millard renewed.
Yes.
Now, Millard, on
Are you all ready with instructions?
No.
Because urgent basis it was
In
moved.
the morning it was served.
Yes.
I couldn't obtain instruction. So far, after going through the repetition, I found that it can be disposed of
Yes.
by.
Yes, let him make
Well,
submission. Let
Madam,
him
madam, I'm just giving a proposal, madam.
The state is concerned, but the role of the state at this juncture is nothing.
But they have certain grievance against PCI that PCI has not updated their list in the official
Yes, they
website.
want the details to be uploaded.
Let them write to the PCI and let an order be given to consider the application by PCI with this time limit.
Is a writing required or is it the law that you have to upload
No,
it?
I don't know what is the actual problem, because as of now I don't have any instruction.
Right, right.
If not already done.
so the approved Millard long back, page 32. Is the Millard screenshot from the website of the PCI. Left hand side bottom Millard, it's approved. Now in the middle part, it is for the session Millard 26-27. At the very top. At the very top left hand side. Now Millard, my initial examining body was the State Council. And subsequently I obtained NOC from Millard this.
No, your prayer right now is for uploading the.
Uploading so that
what is to be uploaded?
My name under the Millard website as an affiliated college.
Achha.
Whether it was affiliated or not, as of now, I don't have an instruction, my lord. Let them write to the PCI and PCI shall consider the same.
Page 31 is the proof, Millard, that the PCI has affiliated my name.
25-26.
Millard will kindly see the.
Please come. The petitioner prays for a direction. Now, first step, the petitioner claims to be a college imparting pharmacy education. Stop. The petitioner has annexed document to show that the consent of affiliation was provided by the West Bengal State Council of Technical and Vocational Education, page 26, and Skill Development for the session 2022-23, and the Pharmacy Council of India also approved the affiliation for the session 23-24. Stop. The petitioner is aggrieved as the affiliation status of the college is not reflected in the portal of the Pharmacy Council of India for the session 2025-26. Now, 25-26 uploaded?
Yes, page 32.
Or should.
And from this year, we have sought to change the affiliating body. The affiliating body in this year would be State Medical Faculty.
the state medical faculty is saying to us that we can't approve you because your name is not reflected in the website of the PCI.
Right. So 25-26, was it reflected?
20, no.
25-26, page 31, PCI.
But that has been approved by the PCI, but in PCI's website it is not reflected.
Right. কি বললাম? For the session 2025-2026, stop. The admission for the academic year 2026-27 is ongoing. Stop. Submission is that till the PCI uploads the approval status of the college in the official website, comma, the petitioner is not in a position to obtain affiliation from the examining body.
Instead of 26, 7.
আচ্ছা ঠিক আছে 25-26
May I produce the
ঠিক আছে the matter was mentioned in the morning and the same is taken up for consideration on urgent basis. Stop. The learned advocate representing the Pharmacy Council of India is unable to obtain instruction from his client. Stop. Next. In view of the above, the instant writ petition stands disposed of by directing the Pharmacy Council of India to take necessary steps for uploading the approval status of the petitioner in accordance with law, comma, if not already done. For the session 2025-2026. Stop. If for any reason the status of the college cannot be uploaded, comma, the same shall be intimated to the college forthwith. Stop.
And to the university, my lord.
And to the
university, state medical faculty.
Affiliating body.
Affiliating body. Page 30, your lordship sees.
And to the
page 30.
affiliating
State
body.
affiliating, yes.
State affiliating body. And you are the examining body.
No,
not for
No,
PCI.
earlier they were under us. Now they want to migrate.
Examining body. ওটা হবে state affiliating body. State Medical Faculty of West Bengal. আচ্ছা ঠিক আছে
From council to faculty.
কি বললাম শেষটা? If
for any reason, the status of the college cannot be uploaded, the same shall be
forthwith. Stop. How soon can you do this?
Let them communicate within 7 weeks, it will be done.
7 weeks?
7 days. Extremely sorry. 7 days, it will be done.
date for admission.
They are coming today, my lord.
Yes. See, you are coming on the very last date. You have to take.
And at 1:15, it was served upon me, my lord.
A copy of the mail. This has not been addressed to me because my name was not reflected in the Willard PCI.
When did the admission start?
From 20th of February. 20th February, they have notified.
Right. So you approached the court on the 27th.
It was not sent to me. It was not because it is not a public document, Willard.
Maybe, but then you knew that you could not get admission, take admission for some reason or the other, and you took 1 week time. If you want, this order is being passed now. This will be corrected. This will be uploaded. Then they have to check up as to why it has not been done. Then only it can be done. You have to give them the minimum time.
7 working days, my lord.
PCI decides to affiliate. Then let the university also.
University is not before your lordship now, my lord. The main respondent is not before your lordship right now.
No, here is
No, my lord.
State Council. Respondent number 5, will you not be there? State Medical Faculty of West Bengal. 3.
They are separate bodies, I understand. State medical faculty of West Bengal.
আচ্ছা কি বললাম?
Hospital. State medical council.
ওই যে বললাম না লাস্টে কি ফের আগের প্যারাগ্রাফটা বলুন
একটা বডি আছে।
আচ্ছা ঠিক আছে একটা প্যারাগ্রাফ অ্যাড আপ করুন। Steps shall be taken by the Pharmacy Council of India at the earliest, keeping now in view of the fact that the admission for the course is scheduled to close tomorrow. Stop. In the event the Pharmacy Council of India approves the status of the petitioner, then the state affiliating body shall take necessary consequential steps in this regard. Disposed.
This regard also in accordance with law.
Certainly in accordance with law. The authority cannot take any steps which is contrary to law.
Grateful. Reopening issue abar theke jabe. But ei order dekhi.
Yes.
This is the matter where 4 FIRs and charge sheets are under challenge. Well, I had placed 3 FIRs and 3 charge sheets pertaining to Shakespeare Sharani PS case number 314, 340 and 397. So, only the 4th one is left to be placed. That is the Anandapur PS case number 188 of 2018. Your lordship will kindly take your lordships can take the complaint and the FIR from CAN 4. It is there in the writ petition also and also in the CAN 4 also. Writ petition 5368 in 5368 of 2021, it is at page 125. And in CAN 4 of that same writ petition, it is at page 127.
অনিমেষ বাবু ক্যান 4টা একটু দেখুন না ক্যান 4 ওগুলো সব জাজমেন্টের কথা হ্যাঁ খুলে দেখুন এফিডেভিট এখানে আছে হ্যাঁ ক্যান 4 না ক্যান 4 একটা বড় Which page did you say?
127 of CAN 4.
Yes.
Well, your lordships will find that this FIR was registered under sections 420, that is cheating, 406, that is breach of trust, and 465 to 468, which are all pertaining to forgery, normal forgery, forgery of court papers, etc., etc., and 120B and 34.
Yes.
Now, my lord, we need to only concentrate on 420 and 406 and 120B, because, my lord, as far as the forgery is concerned, no charge sheet was filed with regard to that. So, my lord, as far as the ingredients in the complaint is concerned, we need to concentrate on 420, 406 and criminal conspiracy. Now, my lord, the complaint is in the next page onwards, page 128. My lord, kindly takes it. Your lordship will find at in the subject itself, the name of the writ petitioner will appear in the second line of the subject. Now, kindly, my lord.
Is his name Mojumdar?
Majmudar. Majmudar.
Here it is.
It's a Gujarati origin.
Parag Majumdar is mentioned.
In
here.
the your no Majmudar is mentioned, my lord. MAJMUDAR.
Oh, acha.
MAJ, yeah.
ঠিক আছে. Yes.
My lord, may I place the complaint, my lord,
Yes.
in its entirety? I, Anil Bhutoria, son of so and so, residing at so and so, herein referred to as the undersigned, would like to bring to your notice acts of cheating, misappropriation of huge amount of amount by inducement illegally perpetrated by accused persons being Rajesh Agarwal, Vedant Agarwal, Parag Majmudar, and Ghansham Das Sharma, who were managing and controlling the day-to-day affairs of the above mentioned companies, along with the present directors, namely Arun Kumar Mohta, Rajshri Mohta, and Manoj Kumar Sharma. The undersigned is a very well-reputed businessman and is associated with the various companies in the capacity of director. That the undersigned, over a period of 35 years of experience in the business fraternity, has earned huge goodwill and repute in the genre of real estate development. The undersigned, having considerable knowledge in the field of the real estate, was approached by one Rajesh Agarwal, who represented himself to be the director as also the promoter or shareholder of the companies which functions under the name and style of Messrs. Leonine Estate Private Limited and Messrs. Leonine Adobe Private Limited. The said person further introduced Mr. Parag Majmudar, Mr. Vedant Agarwal, and Mr. Ghansham Das Sharma as directors, shareholders, promoters of the said companies, herein referred to as the accused companies and accused persons. The accused person further informed the undersigned that their companies had purchased approximately 130 kathas of land through various companies, 18 in total, and amalgamated and numbered as premises number 736 Madurdaho Police Station, Anandapur, under Kolkata Police, ward number so and so, so and so, so and so, and were intending to develop the same into a residential complex. Well, I just pause here for a moment because since one Friday after another it is being taken up. You will remember I had read out a charge sheet in 397 where also it was mentioned that several companies of this person are there and the money generally gets transferred from one company to another. The accused person further requested the undersigned to be a part of the said project, as they would highly benefit from the expertise and goodwill of the undersigned in development of the project. The undersigned was initially skeptical about being involved in such project, as he was uncertain about the creditworthiness of the said accused company. That on expressing his lack of interest, the accused person immediately showed various documents purporting to be deeds of conveyance showing ownership of the companies on the said plots of land. Various applications for sanction made to various government departments and also various bank details to portray their creditworthiness was also shown to the undersigned to induce him that upon gaining the trust of the undersigned, the accused persons requested the undersigned to invest in the said project as it would fetch high returns. Further, the undersigned was requested to act as developer against the accused persons in developing the project, and in due course of time an agreement to that effect would also be entered into for securing the right of the undersigned in the project. It was further portrayed by the accused person that the accused persons were having a total of 18 companies and all the companies would be a part of the developmental project. The undersigned was requested to invest only in two companies, namely Leonine Estate and Leonine Adobe, which were portrayed as the principal companies which would be undertaking the development work. The details of the said 18 companies floated by the accused persons are annexed to this letter for your perusal. That being deceived by such false representation and promise, the undersigned had invested huge sum of money on various dates in the form of checks made in favor of the accused companies, namely Leonine Estate Private Limited and Leonine Adobe Private Limited, totaling to rupees 60 lakhs, and for 4 lakhs was paid to the architect, namely E-Space. Stop. Well, just pausing here for a moment. Well, the judgment shown by my learned senior, I was going through all of them. They are in the, some of them are in the line that the deed has been done by the company, not the director. Well, I'll distinguish those on fact, but since I'm reading this complaint, well, I'll only point out the paragraph above, the longish paragraph, clearly makes out a complaint that the accused persons were giving him some representation, promises and assurances to part with the money being the investment. So it is not really the company who is making the deception according to the complainant, these persons. And your lordship will also find in these 4 or 5 pages of complaint two distinguishing words, person and persons. Persons means this group of Parag Majmudar, Vedanta Agarwal, and Ghanshyam Das. And person, which I've understood it in the complaint, is Rajesh Agarwal. When he refers to person, he means Rajesh Agarwal. And when he refers to persons, he means these three persons as a group. The anvil of fifth last line from the bottom. The anvil of making such payment was on the promise of entering into a development agreement, a JV agreement between both parties within a period of 6 months. The money which was given by the undersigned in his personal capacity through companies, namely Abcon Properties Private Limited and AK Foundation, both the companies have their registered office at so and so, was solely for the purpose of developing residential complex and not for any other purpose. The details of the payment made by the undersigned in both the companies of the accused person are annexed for your perusal and marked as Annexure A. That after such investment was made by the undersigned, the accused persons for extracting further money from the various people using the goodwill of the undersigned made him the director of the companies, namely Leonine Estate and Leonine Adobe, on 22nd June. That slowly the accused person for collecting money from other business entities and banks made the undersigned as the face of the project. In the said manner, the accused person further collected 3 crores 83 lakhs approximately from various other entities who had given money, only seeing the presence of the undersigned in development project. On the other hand, the undersigned was made a director to gain trust and in order to ostensibly show that there was transparency in the dealing of the accused company. Over a period of time, the undersigned realized that the undersigned was being used only as the face of the project, as the undersigned was never made to attend any board meetings or take part in the decision-making procedure, though the undersigned was portrayed as the director of the accused company. The undersigned was not only prohibited to take part in the running of the company, but also not made aware of the decisions which were taken by the accused persons. The undersigned was also not intimated regarding the board meetings held in the companies, nor was he permitted to become a signatory to the affairs of the company. The undersigned was also never made signatory to any of the bank accounts so as to deny the undersigned access to any kind of banking transactions which were undertaken by the accused company. The undersigned was also not empowered to act as a signatory to any transaction occasioning qua the companies. For all intents and purposes, the undersigned was made to act as an object of advertisement of the project. In fact, on few occasions other than the investment made by the undersigned in the companies, the undersigned had effected payment to the architect of the project as the companies did not effect payment to the said person for the reasons best known to them. In hindsight, it becomes palpably clear that the companies did not effect payment because accused persons knew that since the undersigned was in touch with the architect, it would be embarrassing for the undersigned to deal with him when no payments were being made by the companies, and the undersigned will be forced to pay to ensure the fact his goodwill was untarnished. That over the period of 9 months, when the undersigned remained the director of the company, the undersigned realized that the representation made by the accused person to the undersigned were all false, dubious, and made only with an intention to defraud the undersigned and various other well-wishers and the undersigned who had invested in the project, seeing the participation of the undersigned. The undersigned, realizing the non-transparency and unclear dealings of the accused persons on various occasions, has sought for explanation regarding the financial investments made and usage, and also the time frame in which the joint venture agreement would be executed. However, the accused persons were evasive in their answers. That subsequently the accused persons, realizing that the undersigned has understood the modus operandi of the accused person in defrauding the people, the accused person created an uncongenial environment for which the undersigned was forced to resign from the directorship of the accused company on 1st November 2013. The undersigned was also made to believe that in the event he resigned, the accused person would promptly enter into a JV agreement with them. It is stated that one of the cause of resignation of the undersigned was the accused company was the assurance given by the accused person that within 3 months from the date of resignation, the JV agreement between the undersigned and the accused companies would be signed, which would inter alia include the details of the investment made by the undersigned. The accused persons had further assured that they shall furnish the details of the financial positions of the companies and also clearly show as to how and in which manner they were planning to use the investment made by the undersigned as also the other investors. That since the date of resignation, the accused person had a complete change of attitude toward the undersigned, and to any queries which were made by him. That on repeated occasions, the undersigned had made attempts to meet the accused persons and inquire about the execution of the agreement, but the accused person, on some pretext or the other, on delaying the procedure. The undersigned finally, after almost 3 years of his resignation from the companies, came to learn that not only the undersigned but the accused persons have defrauded and or cheated various other people in the similar manner, and the checks so issued by the accused person to other investors have stood dishonored. The said investors are also taking appropriate legal action against so and so. The accused persons, on some pretext, kept delaying the signing of the agreement. During course of discussion, at the time of asking for return of money, the accused persons had shown a document purporting to be a stamp paper bearing the signature of the undersigned and the accused Rajesh Agarwal, which is in the nature of loan agreement, whereby the undersigned had purported rendered financial assistance to the company to the tune of 64 lakhs, issued by both in my personal capacity as well as through companies, namely Apcon Properties and AK Foundation. It is emphatically stated that no agreement was signed by the undersigned and the signature on the said document was false. The document has been created by the accused person to indicate that the money given was by way of loan and the same was to be repaid at the convenience of the company. For this allegation, those sections were there in the FIR. The said fact only shows the modus operandi. The undersigned suspicion was bolstered when the undersigned came to learn that the accused person has sold a substantive share of the business of the accused company to some third party, namely Arun Mohta, and has left Kolkata. On or about 17 July 2017, the undersigned came to learn through his sources as well as through paper publications that the accused persons were planning to develop the property. The undersigned approached the accused persons to execute the joint venture agreement and refund the money. However, the said accused persons have not executed the JV agreement, nor they have refunded the aforesaid money. Therefore, the parting with the money is complete with this allegation. He was made to part with his money. The said Arun Mohta had included himself as director along with Rajshri Mohta, Manoj Kumar Sharma, knowing fully well that this is huge outstanding pending towards the undersigned. The present management, consisting of aforementioned directors, were made aware of the acts of fraud perpetrated by the company coupled with the non-payment of dues. However, the present management also turned deaf ears to the pleas of the undersigned. The fact of the company was owing a sum of 64 lakhs to the undersigned since 2012-2013 was also known to the present directors, namely Arun Mohta had included himself as director of Rajshri Mohta and Manoj Sharma at the time of induction. It is because of the said reason that the management, past and present, have conspired to defraud the undersigned. In the above circumstances, it is amply clear that the accused persons, in connivance with each other, have not only duped the undersigned for a total sum of 64 lakhs, but also made the undersigned face of the project in turn collected huge amount, around 3.83 crores approximately, for their personal wrongful gain. Then, my lord, the request to register it as an FIR and then for apprehending the accused. My lord, though it is not needed, but to criminal manual that they but kindly takes, my lord, 120B, 420 and 406 just for the wordings of it, my lord.
Yes, read out.
Yes. IPC, green IPC. I'm reading it for the timing, my lord. 120B. Whoever is a party to a criminal conspiracy to commit an offense punishable with death, imprisonment for life, or rigorous imprisonment for a term of 2 years or upward shall, where no express provisions is made in this code for the punishment of such conspiracy, be punished in the same manner as if he had abetted such offense. Whoever is party to a criminal conspiracy other than the criminal conspiracy to commit an offense punishable as aforesaid shall be punished with imprisonment of either description of a term not exceeding 6 months or fine or with both. So the allegation of criminal conspiracy is there, more particularly, my lord, quite clearly summarized in the second last page of the complaint. Now, my lord, 420. 406, my lord, I'll just read out first. 405, I'm reading out, my lord. Whoever, being in any manner entrusted with property or with any dominion over the property, dishonestly misappropriates or converts to his own use that property. Own use, I'm stressing a lot because he says that personal wrongful gain to his own use that property, or dishonestly uses or disposes of that property in violation of any direction of any law prescribing the mode in which such trust is to be discharged, or any legal contract, express or implied, which he has made touching the discharge of such trust, or willfully suffers any person to do so, commits criminal breach of trust, and the punishment is in 406. There were after reading 420, I'm coming back to the submission. 420, cheating as dishonestly inducing delivery of property. Whoever cheats and thereby dishonestly induces the person deceived to deliver any property to any person, or to make, alter, or destroy the whole or any part of valuable security or anything which is signed or sealed and which is capable of being converted into valuable security, shall be punished with imprisonment of either description for a term which may extend to 7 years, and shall also be liable to fine. Therefore, my lord, cheating is the design before the act is done, having the intent making someone part with the property. That is clear from the complaint that Anil Bhutoria was made deceived to part with his property. Now he says in the later part of the complaint that after so and so years, I found that they are now developing the project, though they have not entered into the JV with me. So he was made to part with his property for entering into a JV. In place of doing so, as per the complaint, the accused person is diverting that money for doing something else, which may be another JV or another development project, but not with Anil Bhutoria, where 406 comes into the picture. 420 happens first, where he alleges the intention was already there. Then after he parts with the property, 406 happens. And all this happens in a criminal conspiracy under 120B. Now, my lord, in my understanding, all the three sections are made out from the complaint. Even, my lord, forgery was also made out in the complaint, and that is why it was there in the FIR. Now, my lord, kindly comes to the charge sheet, which is at page 136.
20B was not invoked earlier.
Yes, it was there, my lord. In the FIR also there, it survived in the charge sheet.
The other three?
In the other three was, my lord, in 314, it was not there. In 397, it was there. It was there. And in 340 also, it was not there. Only in 397, it was there. But the charge sheet your lordships will find at page 136. Thereafter, kindly your lordship will turn over to 138. Since the year 2011 and 2013 and onwards, 138 accused persons being the directors of Leonine Estate Limited, in furtherance of their common intention, entered into criminal conspiracy, cheated the complainant, committed breach of trust, and misappropriated money to the tune of 64.15 lakhs, which entrusted to them for the so-and-so project at so-and-so, Kolkata 107, giving false assurance to introduce a joint venture by perpetrating and using fake and false documents as genuine. During investigation, visited the PO, examined the witnesses, collected some documents as evidence, and some accused persons were examined by virtue of notice under section 41A CRPC. The accused persons surrendered before the learned court, and so till 10/4/2021, and others are absconding. A prima facie case under 420, 406, and 120B IPC has been established against all the 8 accused persons who may go up for facing the trial, and process may be issued to accused against 3 to 8 for absconding, their appearance before the learned court. The name of the 8 accused person, your lordship will find 2 are there, my lord, in the first page, and 1 in 137. The name of the other 5 are there. Though, my lord, it is though not as elaborate as 397, my lord, the FIR charge sheet in 397, but clearly says that these offences have been found to be made out after examining the witnesses and examining the documents. Now, my lord, this is the crux of the FIR and the charge sheet. Now, my lord, as I was submitting, my lord, the judgments which has been cited, I'll just deal with them, my lord, a few, because my lord, I'm not placing my judgments today, my lord, because I understand there is also rising today. My lord, but since I'm on this point, I have found that the judgments mostly touch upon 420, 406, and probably my learned senior wants to make out a case that since the allegation is against the company, you cannot come and chase the directors. There must be specific allegation against the director, which is there. Now I'll only, in tune of that, I'll only distinguish the judgments. But a one-pager list of judgments was given by my learned senior with the heading point of law. And the first judgment there is SK Alag, 2008-5 টা দাও আজকের গুলোতে আজকের বাঞ্চটা ওটা বাঞ্চটা ওকে দিয়ে দাও, একটা একটু বার করে দেবো। My lord, here my learned senior has shown paragraphs 1 to 12 and paragraph 20.
1 to 12 or only 12 to 19?
My lord, in the note it says, I'm sorry, paragraph, sorry, my lord, it says 1, 12 to 20. I'm sorry. I stand corrected, my lord.
Yes.
So, my lord, in this judgment, your lordships will find kindly take paragraph 8.
Yes.
Inter alia, relying on or on the basis of the allegations made in the complaint petition that the company with malafide intention neither sent the goods nor returned the money, an order for summoning the appellants was passed on 8th of May 2001. A publication to that effect was also made in an article in a local newspaper. So there the allegation was against the company. And in view of the allegation against the company, the directors were summoned. That was the genesis. In this, not only the complainant says accused company, the complainant specifically says the accused persons gave me an assurance. Accused persons made me invest. One accused person introduced me to the other accused persons, and they made me to invest in that company. Also, my lord, your lordships will find in the other paragraph, I'm not reading it, my lord, because my learned senior has also already read it. If your lordship just takes a cursory look at paragraph 12 onwards, what the Honorable Supreme Court discusses are the ingredients. Now, your lordships will see that whether on the face of it, these ingredients are there or not. Whether it can be proved or not will be looked into by the trial court. Your lordship is today not in the trial of the matter. So, the scope is only to see prima facie 405, punishment at 406, 420, and criminal conspiracy is made out or not. Therefore, my lord, 12 to 20, I'm not reading, my lord. Perhaps it will help them, my lord, at the time of trial, if we ever reach that after so many adjournments that they have taken before the trial court. Now, my lord, the next judgment is, my lord, Preeti Gupta, that is 2010 7 SCC. পেয়েছিস
এটা ফেরত দিয়ে দেবেন
লাগবে না
Now it is Preeti Gupta.
Preeti Gupta 10-7
Yes. ফেরত
667.
Yes.
Preeti Gupta, your lordships will find, is pertaining to 498A. In none of our FIRs, 498A is there. So, the principles as far as 498A will not apply. The other distinguishing paragraphs your lordships will find is paragraph, my learned senior has placed 20 to 28 and has said that the main paragraph is 28. So, kindly starts from 28. 28. We have very carefully considered the averments of the complaint and the statements of all the witnesses recorded at the time of filing of the complaint. There are no specific allegations against the appellant in the complaint, and none of the witnesses have alleged any role of both of the appellants. But this itself distinguishes it. If your logic goes on to paragraph 32, 34, and 36, your logic will see that what the Honorable Supreme Court basically discusses, that in the heat of the moment, the couples end up filing complaints against each other and the in-laws under 498A without understanding the consequences and the impact thereof on their lives and the immediate family. For kindly, I'm not reading it, 32, 34, and 36. The Honorable Court is discussing that what they have seen in their judicial career, ultimately what it leads to, and suggests that if an amicable settlement can be reached, please reach an amicable settlement. That's the long and short of the judgment. Now, my lord, next one which has been shown is Inder Mohan Goswami. That is 2007, volume 12 SCC, page 1. My learned senior has placed 21, 22, 42 to 46. Here your lordships will kindly take, kindly gives me a moment. First, kindly sees, but two things are there. In this judgment, my learned senior has shown for the scope of this court under 482 to quash a criminal case. On that, he has shown it. But kindly first takes on that point, paragraph 27. I'm not really going on the point that it's a 482 point judgment, because your lordship is sitting in 226, your lordship has a greater amplitude of power. 27 kindly says, the power possessed by the High Court under section 482 of the Code are very wide, and the very plenitude of the power requires great caution in its exercise. The court must be careful to see that its decision in the exercise of this power is based on sound principles. The inherent power should not be exercised to stifle a legitimate prosecution. The High Court should normally refrain from giving a prima facie decision in a case where all the facts are incomplete and hazy, more so when the evidence has not been collected and produced before the court, and the issues involved, whether factual or legal, are of such magnitude that they cannot be seen in their true perspective without sufficient material. Of course, no hard and fast rule can be laid down in regard to cases in which the High Court will exercise its extraordinary jurisdiction for quashing the proceedings at any stage. Therefore, my lord, if your lordships find some legitimacy in the prosecution, your lordship will not stifle it, because since it is not a trial court, all the materials are not before your lordship. And your lordships have seen, at least even if we keep aside 188 Anandapur PS, the 3 Shakespeare Sharani PS cases have extremely convoluted facts. Though my learned friend, my learned senior has strenuously argued that these are all contractual disputes, civil in nature, some judgments also he has shown, but civil dispute is with regard to ownership of the land, whether in the will which was not probated, whether the granddaughters could sell it, whether Sanjay Sureka was entitled to the land, whether the title shifted there. But the complaints are not with regard to that. The complaints are on the basis of attempts by the writ petitioner and his henchmen to grab the physical possession of the property. And the 3 complaints are of 3 dates when this attempt was made. So, it is, though a picture is being painted that these are all civil disputes, and also with regard to Anandapur PS. case that it's a Lionel Adobe and Lionel so and so has taken the money. It is the allegations against the company. Nothing is touching upon the Parag Majmudar as the director. But the complaint itself shows that it is not so. The complaint is directly against him. Now, kindly in that light, take paragraph 21 of that judgment, Inder Mohan Goswami. We have page 10. We have heard the learned counsels for the parties at length. The appellants who are office bearers of a charitable organization, namely Sanatan Dharma Pratinidhi Sabha, in order to protect the interest of the Sabha, cancelled the power of attorney by executing a registered cancellation. Registered cancellation deed after giving notice to the power of attorney holder. The appellant sold only that part of the land to Sunil Kumar on behalf of the Sabha for which an agreement to sell with the complainants, the respondents, had already been terminated. The respondents' earnest money had been forfeited. All of this was done only after the appellants had given the respondents due notice. So, this is the facts on basis of which Inder Mohan Goswami is given. Apart from the powers under 482, those are settled principles. And I'll show 482 powers or 226 powers for quashing will not apply in our case. I'll show those judgments also when I show my judgments. Then kindly takes the next one, Uma Shankar Gopalika, 2005 10 SCC 336. Well, shall I hand over a copy? Here your lordship kindly takes paragraph 3 and paragraph 6. Here the only allegation was an assurance of getting 4,20,000 as an insurance amount. This is on whether 420 and 120B applies or not. First of all, one of my points is that it is to be seen in trial. Apart from that, in the judgment, kindly see paragraph 3. The short facts are that the Madhusudan Ram Gupta, respondent number 2, filed a complaint in the court of Chief Judicial Magistrate Dhanbad bearing complaint case number so and so for prosecution of Messrs Gopalika Finance within the district of Bardhaman and his two directors, namely the appellant and his brother Vijay Shankar under 420 and 120B alleged herein, inter alia that Messrs Gopalika Finance was engaged in the business of financing the purchase of vehicles under the hire purchase scheme, and the complainant was who was desirous of purchasing a truck approached the accused persons for financial assistance in the year 1991, whereupon the appellant and his brother Vijay Shankar agreed to finance the purchase of truck by the complainant on hire purchase agreement. Pursuant to the said agreement, the complainant made over his part of the investment by paying a sum of 1,60,000 to the appellant. He also handed over various documents to the appellant. Thereafter, on payment of the balance price of the vehicle to the dealer by the financer, chassis was made over to the complainant, who spent a sum of rupees so and so for building body of the truck, whereafter the truck started plying. The complainant could repay only 3 installments to the financer. In the meantime, on 30th November 91, the truck in question, loaded with goods, became traceless, for which the matter was reported to the police as well as the insurance company. The complainant submitted a claim before the insurance company to the tune of 4,20,000. According to the complainant, thereafter on 20th July, the appellant called upon him at his Sindri house and introduced him to permit the appellant to handle the insurance claim, which request was acceded to by the claimant on assurance given by the appellant that when the claim of 4,20,000 is received from the insurance company, out of that sum of rupees 2,60,000 which the complainant was entitled to receive would be paid to him. Upon this assurance, a complaint was made by the accused person before the West Bengal Consumer Grievance Redressal Forum, in which the complainant was also made a party by an order dated 23rd July. The entire claim was allowed and the insurance company was directed to pay 4,20,000 with interest accrued thereon. And pursuant thereto, the insurance company issued a check of 4,20,000 in favor of the corporation, which was encashed by the appellant, but out of the said amount, a sum of rupees 2,60,000 was never paid to the complainant in spite of assurances given to him by the appellant, which necessitated filing of the complaint for prosecution of the accused person. Then 6. Now the question to be examined by us is as to whether on the facts disclosed in the petition of complaint any criminal offence whatsoever is made out, less offences under section 420 and 120b. The only allegation in the complaint petition against the accused person is that they assured the complainant that when they received the insurance claim amounting to rupees 4,20,000, they would pay 2,60,000 to the complainant out of that, but the same was never been paid. Apart from that, there is no other allegation in the petition of complaint. It was pointed out on behalf of the complainant that the accused fraudulently persuaded the complainant to agree so that the accused person may take steps for moving the consumer forum in relation to the claim of 4,20,000. It is well settled that every breach of contract would not give rise to an offence of cheating, and only in those cases breach of contract would amount to cheating where there was any deception played at the inception. If the intention to cheat was developed later on, the same cannot amount to cheating. In the present case, it was nowhere has been stated that at the very inception there was any intention on behalf of the accused person to cheat, which is a condition precedent for an offence under section 420 of the IPC. But here I'll only remind your lordships of one line in the complaint, that in the hindsight I have now realized that this design was made only to utilize my name to defraud many other people. So obviously, my lord, when the transaction is happening, if I can understand that I'm being defrauded, I will not enter the transaction. Question is not that. Question is not when I realized. Question is whether that the design was, motive was there from the beginning or not. Now, my lord, the next one. Kapil Agarwal, 2021, 5 SCC 524. My learned senior has placed 18.1. (18.1) as observed and held by this court in a catena of decisions, inherent jurisdiction under 482 CRPC and under 226 of the Constitution is designed to achieve salutary purpose that criminal proceeding ought not to be permitted to degenerate into weapon of harassment. When the court is satisfied that the criminal proceedings amount to an abuse of process of law, or that it amounts to bringing pressure upon the accused in exercise of the inherent power, such proceedings can be quashed. So, the thing which has to be considered by your lordship, that whether the complaint and thereafter the charge sheet are such that which reeks that it's made only to wreak personal vengeance upon these persons by this Anil Bhutoria. As far as this is concerned, but I believe that this applies to all the 4 cases. As far as the other 4 cases is concerned, Malad, I have consistently shown that it was regularly these attempts were being made according to the complainant for taking possession of the property. Therefore, it is not, on the face of it, does not seem to be something just to wreak vengeance. Malad, may I place my judgments, Malad, on the next day, Malad?
There are other judgments?
Yes, Malad, there are 1, 2, 3, 4 other judgments cited by my learned senior, Malad.
Then on the next day, we'll continue?
Yes, Malad. But if, hopefully, Malad, if I start at 2 o'clock, I'll be able to finish on next day.
I keep it at 2,
Right.
but something.
I understand. I'm not.
What to be done?
Nothing.
And then 3:30s are there.
Friday 3:30, no matter what.
Unforeseen incident we cannot see.
Right.
Cannot portray our face.
No, I also want to finish it. So much facts, I don't want to remember so much facts.
Then Senior Standing Counsel of the state continues with the argument. List for further argument on 6th March, 2 p.m.
আপনাদের ডোমেনের মামলা এত পড়তে হচ্ছে, আপনাদের এগুলো মায়ের হাতটা খেল হয়ে গেছে। 3 গুণ পড়তে, 5 গুণ পড়তে।
অনিমেষ বাবু
Are